of Nirvana is now in session. The Honorable Eddie McShan presiding. All those having business before this honorable court, brought forward and be heard. Your Honor, today, the first case on today's docket is People versus Lindsay Gordon. Defendant and all counsel are present.
Good morning, everyone. Please be seated.
And before we commence, Your Honor, moving forward taking, and we'll have the defense count first. And
For the people.
defense count first. And all team members and the teacher, coaches, and advisors. Behind the judge and the chair.
Good morning.
Good morning.
Good morning. Good morning. Good morning. Good morning. Good morning.
I guess the mother, I have a mother, I think we're fine.
Sure? Okay.
Should we get the whole thing?
Just want to be on my daughter though.
Thank
Good luck to you guys.
Thank you.
Okay, prosecution.
Wait, we aired. I didn't have the rest of the team come up. I should have had the defense. Can we do that again?
Yeah.
I only had half of the team.
That's what I was asking, if you had other people.
I air.
Okay, go back up. The other
So
resident team?
Caleb and Nora and Elliot and Ethan. I apologize.
Oh, no problem.
Sarah.
Good morning again. Okay. We forgot somebody. Right?
Third time's the charm.
Good morning. Good morning.
Good morning.
Good morning. Good morning. Good morning, everyone. Okay, good luck.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, give me 1 second. Okay, good morning, everyone. Are there any applications before we get started?
Good morning, Your Honor. My name is Lily Post, and I, along with my co-counsel Emily Kist
Good morning, Your Honor.
Good morning.
and Maddie Heckman,
Good morning, Your Honor.
will be representing the people in today's proceedings. Before we begin, we just have a few housekeeping matters we'd like to address. First off, we have a notice of appearance for you,
May I approach, Your Honor?
Yes.
and let the record reflect we've already handed opposing counsel a copy of our notice of appearance.
Okay,
Your Honor, may we move freely about the courtroom?
absolutely.
We ask that all witnesses, with the exception of the defendant, Ms. Gordon, be constructively sequestered.
Would the defense like to be heard on that application?
No objection, Your Honor.
All right, the application is granted.
With respect to objections, would you like them stated just objection, objection with grounds, or objection and proceed into argument?
Defense like to be heard on that application.
I believe objection and then grounds, Your Honor.
Okay,
And then,
that's acceptable.
and then finally, where would you like exhibits to be placed after they've been moved into evidence?
I'm gonna leave that to the bailiff. You can,
No further housekeeping matters, Your Honor.
okay, anything from the defense?
Yes, Your Honor. At this time, the defense requests to make appearances for the record.
Absolutely.
Before I do that, I have a roster for your convenience. May I approach?
Yes, please.
Let the record reflect I also have a copy for opposing counsel. Good morning, Your Honor. My name is Hannah Trevorst. I'm here with co-counsel Carter Van Amber
Good afternoon. Good morning, Your Honor.
Good morning.
and co-counsel Don McMara.
Good morning, Your Honor.
Good morning.
Playing Miss Gordon is Miss Isabel West. Good morning, Your Honor.
Good morning.
Playing Mr. Casey is Mr. David Zhao.
Good morning, Your Honor.
Good morning.
And playing Miss Leslie Neal is Miss Sophie Van Amber. Good morning, Your Honor.
Good morning.
Your Honor, the only other request the defense make is that we would move freely about the courtroom, but only within the well, not about the whole courtroom.
Okay, the application is granted.
With that, the defense is ready to proceed.
Okay, sound like we're ready to go. All right, are the people ready to present their opening statements?
Yes, Your Honor.
Okay. And that'd be Ms. Kiss?
Yes.
Okay.
May I proceed?
Yes.
This is a case about lies, loans, and Lindsay Gordon. Good morning, Your Honor. My name is Emily Kiss, and today I, along with my co-counsel, will be representing the people of the state of Nirvana. Your Honor, today we have the burden to prove, beyond a reasonable doubt, that Lindsay Gordon is guilty of committing arson in the 3rd degree. Today, you will learn that Miss Gordon refused to just do the right thing and pay her debts. A woman willing to do anything to prevent her failing business from going bankrupt. And Your Honor, burning down her own paint store was not off the table. In 2016, the defendant, Lindsay Gordon, opened up Gordon Payment Supplies, or GPS, which initially had several customers and loyal employees. However, once COVID hit in March of 2020, the business began to struggle to stock its shelves and even had to lay off most of their employees. Because of this, the defendant decided to reach out to her financial advisor and friend, Brian Casey. Due to the tremendous amount of debt that the defendant was in, Ms. Casey advised the defendant to seek out federal or state loans that could potentially help her business. And despite knowing the risks, the defendant eventually personally guaranteed a $250,000 loan, which still did not save her business. As GPS declined, the defendant's agitation grew, and she even began to take it out on her employees who had been committed to GPS through thick and thin. Still, this did not change the fact that the defendant was falling behind and owing more money by the day. So, instead of filing for bankruptcy, as was her right, she decided to defraud her insurance company to benefit from the money. With a $2 million insurance policy, the defendant was relieved of her debt and able to rebuild her business. So, the defendant, desperate to save her failing business and reputation, devised a plan. First, she invited Brian Casey out to Lights Out Bar and Grill on the night of July 28th, a bar that was intentionally chosen because it was within walking distance of her paint store. The defendant also knew that Brian Casey would have to take a phone call that night, simultaneously giving her an alibi and a brief window to run to her paint store and burn it down. So knowing nobody would be working that night, the defendant entered her paint store, poured gasoline on the floor, and then started the fire with the lighter that she always carries. But Your Honor, the work was not done just yet. She then broke the back door's window to stage a fake break-in that she could ultimately pin on her former employee, Pat Wheeler. Within minutes, the building was engulfed in flames. The defendant then ran back to the paint store just in time for Miss Casey to see her drenched in sweat and completely out of breath. Today, Your Honor, the people will call Investigator Kelly Severide to the stand, who was tasked to investigate the fire itself, evidence, and witnesses. Between the insurance policy that the defendant had, which would relieve all of her debt, her unreliable alibi the night of the fire, and direct access to a lighter and gasoline found in the trunk of her car. Severide saw that it was clear all the evidence pointed to the defendant. Now, for investigators' investigation, she conducted interviews, one of them being with Pat Wheeler, but because of the interview that she conducted with Mr. Wheeler, evidence compiled an overwhelming amount of proof pointing to the defendant. Pat Wheeler was not pursued any further. Next, the people will call Pat Wheeler to the stand, the former employee of Gordon Paint Supplies. Today, the evidence will show that Mr. Wheeler was a dedicated, longtime employee of GPS. In fact, he was one of the 4 employees that stayed through the financial struggles of COVID. But despite this, the defendant still used Mr. Wheeler as a scapegoat for her devious scheme. Next, the people will call Tracy Bickle to the stand, a former business partner of the defendant. Today, the evidence will show that Mr. Bickle saw the defendant the night of the fire exiting the back alley of Lights Out Bar and Grill and making her way to Gordon Paint Supplies. Your Honor, today we have the burden to prove beyond a reasonable doubt that Lindsay Gordon is guilty of committing arson in the 3rd degree. Later today, my co-counsel, Lily Post, will come before you and ask you to return the only verdict that evidence supports and justice demand. Guilty. Thank you, Your Honor.
Thank you. Is the defense ready to present their opening statements?
Yes, Your Honor.
Okay, you may proceed.
May it please the court. This case screams reasonable doubt. 2 unaccounted for suspects. 1 seen filling up their gas can at 10 p.m. on the night of the fire, just a couple hours before the building burned down. An investigator who was not inclined to follow up. This case screams reasonable doubt. Your Honor, bad investigations lead to bad prosecutions and then bad convictions. Confirmation bias is the enemy of the truth. The evidence today will show that the prosecution will not even prove a crime was committed, let alone that it was committed by Miss Gordon to a moral certainty. Your Honor, the entire burden today rests on the prosecution. The prosecution must prove my client not probably guilty, not very likely guilty, but guilty beyond a reasonable doubt. Not only does the prosecution rule out the possibility of Miss Gordon's innocence, but they must also exclude to a moral certainty every other reasonable hypothesis. They must prove there was no other reasonable suspect for this fire. Your Honor, today the testimony will show that the prosecution will fail in their attempts to show Miss Gordon violated Penal Law Code Section 15010, Subdivision 1, arson in the 3rd degree. Today, the testimony will show that this is the story of an investigation, and an investigator laser-focused on one and only one suspect from the very beginning, having tunnel vision to that end, failing to follow basic protocol, immediately coming to conclusions, tipping off witnesses, and failing to consider and explore other suspects. But further, the evidence today will show that this was all to the hurt of my client, Miss Gordon. Miss Lindsay Gordon, proud entrepreneur and owner of Gordon Paint Supplies. She called it GPS. Who loved her business, loved her employees, and was looking to work through the difficult business effects of a once-in-a-lifetime COVID pandemic. So, Your Honor, the defense will call 3 witnesses to the stand today. First, we will call Miss Lindsay Gordon. Her testimony will address the difficulties running a company during a once-in-a-lifetime COVID pandemic, about her love for her employees, her wanting to do everything she could to spare their jobs, but also about her wrestling with the need to take difficult measures, especially with respect to bankruptcy. Second, the defense will call Mr. Ryan Casey to the stand, longtime financial advisor of Miss Gordon. Mr. Casey will testify about the financial difficulties caused by COVID for GPS, but also about the possibilities that were before Miss Gordon, especially with respect to bankruptcy. And third, Your Honor, the defense will call Ms. Leslie Neal, longtime employee of Gordon Paint Supplies. Her testimony will focus on what she saw in the night of the fire, namely, a disgruntled ex-employee filling up her gas tank just 2 hours prior to the fire. And further, that this same ex-employee threatened Miss Gordon and her business. Your Honor, we believe today that the testimony will show the prosecution will fail to meet their high burden in at least 3 ways. First, the prosecution's investigation was biased, tainted, wholly inadequate. Second, the prosecution simply provided insufficient evidence, failing as required to rule out the possibility of Miss Gordon's innocence. And third, the prosecution will fail their obligation to exclude to a moral certainty every other reasonable hypothesis. Your Honor, people from the beginning of time have fallen prey to confirmation bias. Investigator Severide fixated herself on the very first suspect she got a whiff of and blinded herself to every other possibility. Confirmation bias is an enemy of the truth. Bad investigations lead to bad prosecutions and then bad convictions. Your Honor, this case screams reasonable doubt. Accordingly, at the conclusion of today's trial, we will ask that you find our client, Miss Lindsay Gordon. Thank you.
Thank you, counsel. All right, are the people prepared to call their first witness?
The people call Kelly Severide.
Okay, please take a stand.
Step into the box. Raise your right hand. You promise to tell the truth, the whole truth, and nothing but the truth.
Yes, I do.
Let's see.
May I proceed, Your Honor?
Yes, you may.
Please state your name.
Kelly Severide.
What's your current position, Miss Severide?
I'm currently a senior arson investigator.
What's your educational background?
So I received a degree in criminal justice in 1992. Then I went on to be a police officer for 12 years after going through all of the necessary training for that. I saw an opening in arson investigation and I switched over to that, and I've been in arson investigation for 15 years now.
What kind of training did you have to go through when you transitioned from being a police officer to becoming an arson investigator?
I went through all of the required training, and I still continuously learn about fire science, engineering, and chemistry.
What are your typical steps in an investigation?
So first, I like to look at a scene, gather physical evidence, and see the actual building or anything that could have burned down. Then I move on to gathering important interviews and conducting those, and I bring all of my findings and research to the Property Crimes Bureau Chief and the Fire Commissioner.
Your Honor, permission to approach for the purpose of marking the exhibit.
Okay, you may.
I'd like to mark this photograph as People's Exhibit A. This diagram of People's Exhibit B. I have clean copies for Your Honor as well.
People's Exhibit A and People's Exhibit B marked for identification.
I'm now showing opposing counsel, which has just been marked as People's Exhibit A and People's Exhibit B for identification. May I approach the witness?
Yes, you may.
Ms. Severide, I'm handing you what has just been marked as People's Exhibit A and People's Exhibit B for identification.
Okay.
Can you identify Exhibit A for me?
Yes. Exhibit A is a photograph of the lighter that I saw in Lindsay Gordon's possession.
Is this an accurate representation of the lighter you saw in Lindsay Gordon's possession?
Yes, it is.
Were you made aware that Lindsay Gordon had this lighter the night of the fire?
Yes, I was.
Let's talk about Exhibit B. What is this document?
This is the diagram that I made of the Noble gas station.
What night is this diagram depicting?
July 28th, the night of the fire.
And what specifically is on this diagram?
Pat Wheeler's location and Leslie Neal's location.
Your Honor, at this time I'd like to move People's Exhibits A and B into evidence.
Any objection from the defense?
Yes, Your Honor. If I just may clarify, the exhibit of the lighter is People's Exhibit A or People's Exhibit B.
Okay. Exhibit A is the lighter.
Exhibit A, I object that for Exhibit A, there's been a lack of foundation laid as to how this witness can authenticate that this is the same lighter possessed by Ms. Gordon as there has not been a foundation laid, even though this may look like the lighter or be similar to it, there's been no lack of foundation as to if this is the same lighter that Ms. Gordon possessed and how it came to be in this witness's possession.
Okay, would people like to be heard on that?
Yes, Your Honor, as Ms. Severide just stated, she was made aware that this is Ms. Gordon's lighter through her interview. She observed it in Ms. Gordon's possession, and if allowed to continue, Ms. Severide will testify to that interview specifically with Lindsay Gordon and when she first learned of the lighter.
Okay. I'm not sure if the foundation has been set on the lighter yet, so I'll let you continue to try to establish that foundation. So I'm going to sustain the objection.
Yes, Your Honor.
Let's talk about Exhibit B first, Ms. Severide. You said this is the diagram of the Noble gas station.
Yes.
Where did you obtain the information depicted in this diagram?
I obtained all the information from my interview with Pat Wheeler and with Leslie Neal.
After conducting these interviews, did you continue to consider Pat Wheeler a suspect in this investigation?
No, after I interviewed with Pat Wheeler, I really didn't see him as a suspect any longer.
Why is that?
Well, I talked to Pat Wheeler, I heard his answers, I considered everything carefully, and I really didn't consider him as a suspect. That was not where the evidence was leading me.
Let's circle back to the beginning of your investigation. What did you notice when you first arrived at Gordon Paint Supplies the morning of July 29th?
I noticed that the entire building was almost completely burnt down.
Did you perform any tests that morning?
Yes, I did. I used my combustible gas detector to determine the accelerant of the fire.
What did that device read?
It clearly read that the accelerant was gasoline.
Were you made aware of a security system in place at Gordon Paint Supplies?
Yes, I was, but I sadly couldn't investigate the physical device because everything had almost burned down in the fire.
Did you learn who had access to the disarming code for this device?
I learned that Lindsay Gordon and a few of her employees had this.
Objection, Your Honor. I believe there's been a lack of foundation laid as to how the witness could come to know this knowledge, this testimony.
I'm going to overrule at this point.
Yes, Your Honor.
Okay.
Ms. Severide, let's talk about your interview with Lindsay Gordon specifically. What did you notice about Ms. Gordon when you interviewed her?
While I was asking Miss Gordon some questions, pretty typical questions, her answers seemed kind of evasive to me.
Objection, Your Honor. The witness is speculating.
Overrule.
Yes.
Were you made aware of anything Ms. Gordon had on her person during your interview?
Yes, when I asked Miss Gordon for her identification, just because I always take that, a lighter had fallen out of her pocket, and she made it clear that it was her grandfather's and she always carried it.
So you spoke to Lindsay Gordon about this lighter?
Yes, I did.
Is this the lighter that's depicted in People's Exhibit A for identification?
Yes, it is.
And did Ms. Gordon tell you that she had this lighter on her possession the night of the fire?
Yes, she did.
Your Honor, at this time, I'd like to move People's Exhibit A into evidence.
Any objection?
Your Honor, I still believe there has been a lack of foundation laid as to the chain of custody of this exhibit and how it came to be from Ms. Gordon's possession into this witness's possession.
Your Honor, if I may.
Yes.
This is a photograph of the lighter, not the lighter itself. This photograph was never in Ms. Gordon's possession.
All right, I'm going to overrule the objection. Exhibit A into evidence.
Yes, Your Honor.
What else did you learn from your interview with Lindsay Gordon?
I learned that Miss Gordon always carries a gasoline container, so I went to look at that since it was in her truck. When I observed the container, there was some residue on the outside around the lid, and that indicated to me that it could have been recently refilled.
Did you learn anything about the defendant's whereabouts the night of the fire?
Yes, in another interview from Tracy Bickle, I learned that she was outside Lights Out Barn Grill around 12:15 a.m.
Objection, Your Honor. This testimony is based on hearsay.
May I respond, Your Honor?
Yes, you may.
Under Rule 401, my apologies, this is an out-of-court statement. However, we're not offering it for the truth of the matter at this time. If allowed to continue, Ms. Severide will testify to how this statement affected her investigation and the effect it had on her and her subsequent actions rather than the actual facts of the case. However, we do plan to offer this information for the truth of the matter when we call Tracy Bickle to the stand later today. So in that regard, we're offering it subject to connection.
All right, overrule.
Yes, Your Honor.
I'll ask my question again, Ms. Severide.
Sure.
Were you made aware, what did you learn about the defendant's whereabouts the night of the fire?
Well, from another person that I interviewed, Mr. Bickle, he made it clear that she was outside Lights Out Barn Grill at 12:15 a.m. that night.
Why was this relevant to your investigation?
Well, when along through my other interviews, I also talked to Ryan Casey, who said that they were at Lights Out Barn Grill with Miss Gordon the entire night except for this time frame from 12:10 to 12:40, and 12:15 falls in that time frame, so it was relevant that Miss Gordon was outside, not in the bar.
What else did you learn from your interview with Mr. Casey?
I learned about Gordon Payton Supply's finances, and I learned that they were even teetering on the idea of bankruptcy. I also learned about the insurance claim that Miss Gordon had. It was a $2 million insurance claim, and that gave real motive to me.
Throughout your investigation, who did you bring your findings to?
I brought all of my findings to the Property Crimes Bureau Chief and the Fire Commissioner.
What did they decide to do after reviewing the evidence you collected?
They decided to seek an indictment on Lindsay Gordon, and then the grand jury decided to indict Lindsay Gordon.
No further questions.
Okay, thank you. Defense?
Cross-exam, Your Honor.
Yes.
Your Honor, before I begin, may I have the City of Bliss Fire Investigation Report found on page 95 of the case package be pre-marked for identification as Defense 1?
Yes, you may.
May I approach?
Yes.
Defense 1, marked for identification.
For the record, reflect and show the document to opposing counsel. Yeah, good morning, investigator.
Good morning.
When visiting the burnt-out warehouse, you knew right away or immediately this fire was no accident, correct?
Yeah, I know an arson when I see one.
And let's talk about a potential suspect, Pat Wheeler. After the fire on July 29th, you first interviewed Miss Lindsay Gordon, correct?
I did. She was at the scene.
In fact, you were laser focused on Miss Gordon, correct?
Well, she is the owner of the building. I thought that'd be a good place to start.
And it's sure you learned Miss Gordon fired Wheeler, correct?
Around 4 months prior, yes.
Further, upon being fired, you learned Wheeler threatened Miss Gordon, right?
On his way out the door, yes.
And you learned Miss Gordon believed Wheeler lit the fire, correct?
Yes, so I interviewed Mr. Wheeler.
But isn't it true you filed your City of Bliss fire investigation report prior to interviewing Wheeler?
Yes, this is a preliminary report, but I do work on a continuous basis, so I filed this report to keep things moving, and then I went to gather my interview. All of my evidence went to the grand jury.
So that's a yes to my question?
Yes.
Thank you. But it's true that before interviewing Wheeler, you named my client, Miss Gordon, chief suspect, correct?
I did. That's where the evidence led.
Now, eventually, you interviewed potential suspect Wheeler on August 7th, correct?
Yes.
And it's true when interviewing Wheeler, you issued him a warning?
What'd you say?
It's true when interviewing Wheeler, you issued him a warning?
I'm sorry. Can you rephrase your question?
Absolutely. It's true that during your discussion with Pat Wheeler, you issued him a warning.
Yes, I did.
Now, investigator, just like a simple yes or no answer to this question. Do you consider it best practice to warn suspects before hearing their answers to questions?
I can't answer that with just a yes or no. Can I further elaborate?
If possible, if that's I ask you answer with yes or no.
I would say it depends on the person that I'm interviewing and the situation at hand.
So that's a yes?
Overall, yes.
Now, it's also true when interviewing the cab driver, Tracy Bickle, you informed Bickle Miss Gordon was in the Lights Out Bar and Grill on the night of the fire, correct?
Yes.
And again, yes or no, do you consider it best practice to inform potential suspects about key facts of a case?
Well, Mr. Bickle saw Miss Gordon outside of the bar and grill, so he knew that she was there. I just let her know that he was inside. She was inside.
So is that a yes?
Yes.
Thank you. Now, Bickle claimed to have allegedly seen Miss Gordon at 12:10 at night, correct?
Around then, yes.
Okay. But in your filed report, you list Bickle allegedly saw Miss Gordon at 12:15 a.m., a full 5 minutes later, correct?
Yes, again, these are approximates, so things can vary 5 minutes.
All right. Now, in your career, a prior report contained errors, correct?
It did, and I live with that every day.
In fact, an innocent man was convicted of arson based solely on the gross errors in this report.
Objection, relevance.
Your Honor, may I be heard?
Yes, you may.
Your Honor, a fact important to this case is the competency and credibility of this investigator and her investigation that she performed. This testimony goes directly to question the competency and credibility of this investigation as subject to connection, Your Honor. Her past actions and mistakes now directly influence her investigation of this case because her supervisors now see her as a liability, Your Honor. So as a fact important to this case for competency and credibility and how much weight the court should grant her testimony, this testimony is relevant per Rule 201.
Okay, people?
Your Honor, this past mistake or past case was years ago, and under Rule 201, for something to be relevant, it must make an issue of this case more or less probable. Those two cases are unrelated. They're two different circumstances. It doesn't make any of the issues we're here to talk about today more or less relevant.
May I be heard, Your Honor?
I've heard enough. All right, I'm going to overrule the objection. I think it goes to the credibility of the witness. So overrule. Yes, you can answer the question.
Can you re-ask it, please?
Absolutely. It's true a prior report you prepared for investigation contained gross errors, correct?
Yes, it is, and I live with that every day.
In fact, an appellate court noted this report contained material errors, right?
Many years ago, yes.
And this was 2 years ago, correct?
All right, move on.
Yes, Your Honor. And investigator, I'd like to now focus your attention on some of the interviews conducted.
Okay.
It's true while interviewing Ryan Casey, the subject of Wheeler potentially being an arsonist came up, correct?
During my interview, yes.
Yes. And based on your investigation, you learned Miss Leslie Neal also believed Wheeler lit the fire, correct?
Yes, so I interviewed Pat Wheeler.
Further, Miss Neal observed Wheeler on the night of the fire at a gas station filling up a 2-gallon gasoline container, correct?
Multiple hours prior, yes.
Right, and just to clarify for the court, you believe gasoline was the accelerant that started this fire, yes?
Yes, and Pat Wheeler is not the only one that had access to gasoline.
Thank you. But it's true that you still filed your report prior to interviewing Wheeler, correct?
Again, this is a continuous report. I did file the preliminary report, not the final report.
Right. But in this report in which you named my client chief suspect, when time you filed this report, you still had not asked me what they did with the 2 gallons of gasoline that night, correct?
Again, that's where the evidence led at the time, and that's where it still leads today.
Right. Now, that time you filed your report, you still had asked Wheeler why they made threatening statements against my client, Miss Gordon, correct?
Objection asked and answered.
Maybe you heard, Your Honor?
Overrule. You can answer the question.
Can you re-ask it again?
Absolutely. It's true at the time you filed this report, you still had not asked Wheeler why they made threatening statements against my client, Miss Gordon, correct?
At the time of this report, I had not yet interviewed Mr. Wheeler, so I did interview Mr. Wheeler, and all of that information, evidence went to my superiors and the grand jury.
So that's a yes?
Yes, at the time of the report.
Thank you. Let's now refocus on the testimony of Tracy Bickle. So Bickle allegedly saw someone walking down South Popular on July 29th just after midnight, correct?
South Poplar, yes.
And this person wore a baseball cap pulled way down, right?
Yes.
Now, it's true Bickle did not immediately identify this person, correct?
No, he didn't. He looked and he saw them and he let me know.
Your Honor, I ask you strike the latter portion of that answer. It's non-responsive.
Overrule.
Yes, Your Honor. It's true, investigator. It took several minutes before Bickle even realized this person might be Miss Gordon, correct?
I assume that was out of shock, but yes.
Your Honor, I ask you to strike the latter portion, the former portion of the answer.
I'm going to sustain.
Investigator, you admit that Bickle was not able to confirm the person they saw was Miss Gordon, correct?
They confirmed it the best that they could.
So is your testimony today that they were able to confirm the person they saw was Miss Gordon?
Not 100%, but they confirmed it the best that they could.
Let's move on now to your investigative process with respect to Pat Wheeler. When you eventually interviewed Wheeler, you learned that they filled up a 2-gallon gasoline container just 2 hours prior to the fire, right?
Yes, around 10 p.m.
And Wheeler claimed they were filling their gas can to use their lawnmower the next morning, right?
Yeah, he always mows his lawn Saturday mornings.
It's true you weren't able to confirm, though, if he actually did mow his lawn that next morning, correct?
So at the time that I interviewed Mr. Wheeler, it was a few days later, and I wouldn't have been able to tell what day that he mowed his lawn.
So is that a yes to my question?
Yes, I would not have been able to tell.
Thank you. But it is true, during your interview with Wheeler, you were able to confirm that they made threatening statements against Miss Gordon, correct?
Yes, which Mr. Wheeler explained to me.
In fact, Wheeler considered damaging the paint store, right?
Briefly, 4 months ago, yes.
And at this time, you are expecting, you would say that you're entitled to a promotion, correct?
In the next 2 years, yes.
Right. You believe this case proves you're entitled to a promotion, right?
Well, I believe I did a great job on this case, so yes.
Just one last set of questions for you.
Okay.
You learned that Miss Gordon had a casualty insurance policy on her business, correct?
Yes, a $2 million casualty insurance.
She had this insurance policy in 2022, correct?
Yes.
And in 2021 also, right?
Yes, ever since she opened the business.
Right, in fact, going all the way back to 2016, correct?
Correct.
Thank you, investigator, for your time. Your Honor, I have no further questions.
Okay, thank you. Any redirect?
Yes, Your Honor. Ms. Severide, who did you bring all of your findings to throughout your investigation?
I brought all of my findings to the Property Crimes Bureau Chief and the Fire Commissioner, my superiors.
And just to clarify, did this include your interview with Pat Wheeler?
Yes, it included my interview with Pat Wheeler and all of my other information that I gathered.
No further questions.
Okay. Any recross?
Yes, Your Honor. Investigator, it's true that because of your prior investigation. your
Objection,
supervisor-
out of the scope of my redirect.
I didn't hear the question.
Yeah, may I repeat
Yeah.
the question? The question was, investigator, it's true that because so that your supervisor, the fire commissioner, now see the need to closely monitor your work based on your past investigation, correct?
You still have the objection?
Yes.
Okay, overrule. You can answer the question.
Okay, can you ask it again?
Absolutely. It's true that your superiors, as you mentioned, the fire commissioner, now see the need to closely monitor your work for this case based on your past actions.
Yes, but we all work together.
Thank you, investigator. I have no further questions, Your Honor.
Okay, thank you. You may step down.
Thank you. Would you like these exhibits?
Yes. Well, give it to the clerk. Just for the record, Exhibit A is in evidence. Exhibit B was not moved into evidence. I'm sorry. People's A is in evidence. People's B is not in evidence. It was not moved into evidence.
Might be. Your Honor, I believe People's B was moved into evidence.
Defense like you heard?
I
Your Honor,
believe-
believe the Exhibit A, People's Exhibit A was not moved into evidence. People's B.
Well, people A is the lighter.
Yes, Your Honor.
That was moved into evidence based on the further testimony.
Yes. I believe opposing counsel had no objection to.
Or if there's no objection to exhibit, is there any objection to exhibit People's B going into
Your
evidence?
Honor, at this time, there was no mention of People's B being moved into evidence. I'm aware that People's A has been moved into evidence, but there was no mention of People's B moving forward.
Is there any objection to People's B going into evidence?
I have no objection at this time, Your Honor.
All right, so People B will be in evidence.
Yes, Your Honor.
All right, are the people ready to call the next witness?
Yes, Your Honor. The people call Pat Wheeler to the stand.
Okay. Will Mr. Wheeler take the stand?
Box and raise your right hand. Promise to tell the truth, the whole truth, and nothing but the truth.
I do.
A seat.
May I proceed, Your Honor?
Good morning, Mr. Wheeler. Just keep your voice up for the court.
Yes.
Okay, yes, you may begin.
Good morning.
Good morning.
Please state your name and age for the court.
I am Pat Wheeler. I am 29 years old.
What's your current occupation, Mr. Wheeler?
I currently hold multiple part-time jobs.
Where did you previously work?
My last full-time employment was at GPS.
And when did you begin working at Gordon Paint and Supplies?
In September of 2016,
About how long did you work there for?
7 years of my life.
When you first began working at GPS, what kind of job responsibilities did you have?
Well, I mainly worked in customer service. I really enjoyed working with the customers, and I think they enjoyed me being there.
Objection, Your Honor. I believe the last portion of his answer was speculative as to the customers enjoying him being there.
Overrule. I'll allow some latitude.
Now, Mr. Wheeler, do you know who Lindsay Gordon is?
Yes, I do.
Who is she?
She was my boss while I worked at GPS.
Would you be able to identify Ms. Gordon here in court today?
Yes, I would.
Could you please refer to her by an article of clothing?
She is the woman wearing a blue suit behind the defense table.
Let the record reflect that the witness has correctly identified the defendant, Lindsay Gordon.
All right, so reflected.
Now, Mr. Wheeler, what's your relationship with the defendant?
Well, as I said, she was my boss while I worked at GPS. I would say that we had a pretty good professional relationship.
And what impact, if any, did COVID have during your time working there?
Well, it made, due to the financial difficulties, it made everything a little bit more stressful. We also, at GPS, had to lay off most of our employees, so there were only 4 during COVID.
Now, who were these 4 employees that the defendant decided to keep on the payroll?
Myself, Leslie Neal, and then 2 accountants.
Now, Mr. Wheeler, what was it like working at GPS during your last few months there?
Well, it was very depressing. My job in customer service, just due to the lack of customers, kind of got moved into just menial tasks like cleaning and stocking shelves, which to me was very demeaning because it was not what I was originally assigned to do.
And when did your time end at GPS?
In March of 2023.
Why did your time end at Gordon Cleaning Supplies?
Gordon claimed that I was eavesdropping on a private conversation that she was having on the phone while I was just walking by in the hallway.
Now, Mr. Wheeler, exactly how were you able to hear this conversation?
Well, like I said, as I was walking by in the hallway, Gordon always keeps her doors open.
Objection, Your Honor. I believe this witness can testify as to when he walked past the hallway if the door was open, but cannot testify as to the defendant always having his door open, as that is not within his personal knowledge.
All right, overrule.
I'll just re-ask that last question. How exactly were you able to hear this conversation that day?
So, as I was saying, as I was walking through the hallway, Gordon always keeps her door open, which makes it easier to hear people inside. Also, she always keeps her phone on speakerphone. Those 2 things combined just made it really easy to hear what she was talking about.
What did you hear the defendant say?
I heard her say that she would hate to do anything drastic.
Did you hear anything else during this conversation?
Yes, I could clearly hear her clicking on and off the lighter that I know she always carries with her.
Now, Your Honor, I believe that is speculation as to Mr. Wheeler testifying to Ms. Gordon always carrying a lighter with her that is not from his personal knowledge, and for Rule 313 that would be inadmissible.
People like to be heard?
Yes, Your Honor. Mr. Wheeler can testify to what's within his personal knowledge. He testified that he worked at Gordon Cleaning Supplies for 7 years. Also, this was already open, the store was already open on defense's opening.
Okay, I'm going to overrule.
Now, Mr. Wheeler, after you heard this conversation, what happened next?
Well, Gordon saw me just walking by, immediately erupted on me. He was extremely upset that I heard her, appeared extremely upset that I heard her, and then I was immediately terminated.
Now, did you say anything to the defendant in response to being fired?
I did. Regrettably, I may have said it quite angrily at the time, but I said that she would regret this day and to mark my words.
What did you mean by saying this to her?
Well, I simply meant that she would regret losing such a good employee. I mean, I think I did a really good job at GPS, and she would just hate to lose somebody as valuable as me.
Now, Mr. Wheeler, I'd like to move on. Are you now aware that Gordon Cleaning Supplies was burned down on July 28th?
Yes, I am.
So to be clear, how long after your termination did this fire happen?
Nearly half a year.
And where were you the night of July 28th?
I was just running errands in preparation for the weekend.
Specifically, what were these errands?
Well, I do know specifically that I had to fill up some gas so that I can mow my lawn the next morning.
Was it typical for you to mow your lawn on Saturdays?
Yes, I do it every Saturday.
Now, I'd like to turn your attention to investigator Kelly Severide. Did she ever interview you?
Yes, she did.
When did this interview take place?
Early August.
And what did you and Ms. What did you and Ms. Severide discuss about the night of the fire and where you were?
Well, same thing I just told you. I told her that I was, running errands, filling up gas at the Noble gas station.
And what did you tell Ms. Severide about day that you were fired from GPS?
Well, I told her about the statements that both I and Gordon said about how she would hate to do anything drastic. And then I told her that I was fired.
What else did you tell her about the statements that you made specifically?
Well, I did say that I knowingly made them when I was angry, and that I regret them to this day.
Now, Mr. Wheeler, when you were first fired from Gordon Paint Supplies, did you think about getting back at the defendant?
Briefly, yes, I was upset.
And after you had been fired for some time, did you still feel this way?
No, definitely not.
Do you still feel that way today here in court?
Absolutely not.
Were you at GPS the night of July 28th?
No,
So, Mr. Wheeler, to be clear, did you start this fire?
I would never. Absolutely not.
Nothing further, Your Honor. Thank
Okay,
you.
thank you. Defense want any cross-examination?
Yes, Your Honor.
May I proceed?
Yes, you may.
Good morning, Mr. Wheeler.
Good morning.
Mr. Wheeler, you were employed under the management of Miss Gordon at GPS from 2016 to 2023, right?
Yes, I was.
And as an employee, you believe that you had a great relationship with Miss Gordon, right?
I would say that I had a reasonable professional relationship, yes.
But just 4 months before the fire, you were let go, right?
I was fired, yes.
After all those years of loyal service, you believe that you were unceremoniously fired, right?
Yes,
And that this was for no good reason, right?
that's correct.
Yet, Mr. Wheeler, you admit to not having a good attitude at work, right?
Sometimes I didn't have the best attitude at work, yes.
And that a coworker, Leslie, was making you mad, right?
Objection, relevance.
Overrule.
Can you please re-ask the question?
Yes, of course. And a coworker, Leslie, was making you mad, right?
There were some times where I may have been slightly upset with some of my coworkers, I suppose.
Is that a yes, that your coworker, Leslie, was making you mad, correct?
Sure.
Now, on the day of your firing, you were escorted out of the building, right?
I was walked out the building, I guess.
You reacted in anger, right?
I was upset that I was unceremoniously terminated after 7 years of loyal service, yes.
Now, after being unceremoniously fired, you had fantasies, right?
Just right after being fired, but yes.
Mr. Wheeler, you had particular fantasies about how to get back at Gordon, right?
Again, just right after I was fired, but yes.
When you were fired, you spoke to Miss Gordon, yes?
I did.
You told Miss Gordon to mark your words, right?
Yes.
You also told Miss Gordon that she would regret the day she fired you, right?
Yes, she would be losing an invaluable employee.
Isn't it true, Mr. Wheeler, that you thought about doing something to hurt Miss Gordon?
Again, just for a brief moment after I was fired, yes.
You thought about damaging Miss Gordon's property, correct?
Again, just for a brief moment after I was fired, but yes.
Just to confirm, Mr. Wheeler, you thought about damaging Lindsay Gordon's paint store, GPS, correct?
That's what I've been saying, yes.
Now let's move forward to the night of the fire. On the night of July 28th, 2023, you were at a gas station, yes?
I was,
This gas station is in Bliss, Nirvana, right?
as are most gas stations I go to, yes.
Just to confirm, GPS is also located in Bliss, Nirvana, right?
Yes, so is my home.
Now, you had with you a portable plastic gasoline container, right?
Yes, I think that's, yes, I do.
Mr. Wheeler, did you fill up your car that night?
Objection, relevance.
Like
Your
we
Honor, may I
heard?
respond? A fact important to this case is Wheeler's motive means an opportunity to commit arson. The fact that Mr. Wheeler came to a gas station and only filled up his plastic portable gasoline container and can't remember if he filled up his car demonstrates his opportunity and his means to commit arson as he had a plastic portable gasoline container.
May I be heard, Your Honor?
Yes, please.
Relevance makes a fact, this case, more or less probable. We've already established on direct examination that Mr. Wheeler was filling up a gas canister because
he needed gasoline for his lawnmower, which he can't bring to a gas station. And Mr. Wheeler is also not on stand today for arson. So this is just not relevant to today's case.
All right, I'm going to sustain the objection.
Yes, Your Honor. Now, Mr. Wheeler, you spoke to Investigator Severide about the events of this night, yes?
Yes, I did.
You would say that Inspector Severide warned you that someone saw you at Noble gas station that night, right?
She may have said that, yes.
Is that yes to my question? She warned you?
Again, she may have warned me, yes.
Okay. You told Inspector Severide what you said to Miss Gordon when you were fired, right?
Yes, I did.
You told the inspector that you told Miss Gordon to mark your words, right?
Yes, that's what I told her.
You also told the inspector that you told Miss Gordon that she would regret this day, right?
Yes.
And you told Severide that you were angry at Miss Gordon, right?
I was angry after being fired from my loyal service of 7 years, yes.
And you told the inspector that you had fantasies about hurting Miss Gordon, right?
Again, just for the brief moment after I was fired, yes.
In fact, please tell the court, you told Inspector Severide that you thought about damaging Lindsay Gordon's paint store, correct?
Objection asked and answered.
Your Honor, may I respond?
Yes, you may.
Your Honor, I asked this witness whether they had these fantasies. I have not asked this witness whether they have relayed these to Inspector Severide. This is being brought in to show that Inspector Severide had knowledge of this and had knowledge of Mr. Wheeler's fantasies.
All right, people, you want to respond?
Yes, Your Honor. This line of questioning has already been answered. We've established that Mr. Wheeler has informed Investigator Severide of the way that he felt when he was fired during his interview with her already.
May I respond, Your Honor?
No, overrule. You can answer the question if you remember.
Can you please re-ask?
Yes, of course. You told Inspector Severide that you had fantasies about damaging Lindsay Gordon's paint store, correct?
Yes, again, just for the brief moment after I was fired.
And you explained to the inspector how you filled up your gas can on the night of the fire, yes?
Yes, I did.
You told the inspector that this was at 10 p.m., right?
That's the time, yes.
And when you believe the inspector failed to consider you a suspect, you thanked your lucky stars, right?
Objection. Relevance.
Your Honor, may I respond?
Yes, you may.
Your Honor, this is being brought in to show Mr. Wheeler's relief after not being considered a suspect. I believe this goes to Mr. Wheeler's credibility and showing that Mr. Wheeler had thoughts about this and was relieved after not being considered a suspect.
People like to be heard?
Your Honor, again, under Rule 201, this does not make a fact of this case more or less probable. It's fair to say that nobody would want to be considered an arsonist, but it's not relevant.
All right, overrule. You can answer the question.
Can you please re-ask the question?
Yes, of course. When you believe the inspector failed to consider you a suspect, you thanked your lucky stars, right?
I didn't want to be considered a suspect for a crime I didn't commit, no.
Is that a yes to my question? You thanked your lucky stars?
Yes.
Mr. Wheeler, after being fired, you claim that you have moved on with your life, right?
I have.
Yet to this day, you would say you still can't believe that Miss Gordon fired you, right?
It's still surprising to me that she just fired an employee of 7 years of service, yes.
Thank you. Your Honor, I have no further questions.
Okay. Any redirect?
Yes, Your Honor. Now, Mr. Wheeler, have you done anything to harm Gordon Painted Supplies?
No, I have not.
Have you done anything to harm Lindsay Gordon?
Definitely not.
Nothing further at this time, Your Honor.
Okay. Any recross?
No recross, Your Honor.
All right, thank you, Mr. Wheeler. You can step down. Does the people have any more witnesses?
Yes, Your Honor. The people called Tracy Bickle to the stand.
Okay.
Good box, and your right hand. You promise to tell the truth, the whole truth, and nothing but the truth.
I do.
So, seat.
Permission to proceed?
You may proceed.
Please state your name and age for the record.
My name is Tracy Bickle. I'm 64 years old.
What is your current occupation?
I'm a taxi cab driver.
And before you were a cab driver, did you have a different occupation?
I did.
What was it?
I used to co-own a real estate management business with Lindsay Gordon.
And what were your roles inside this company?
I was in charge of business development while Lindsay handled our finances and management.
And when this business ended, how did it affect you?
I was devastated. I put every last penny I had and so much time into that business, and I felt betrayed.
Now, Mr. Bickle, are you aware that there was a fire at Gordon Paint and Supplies the night of July 28th?
I am.
And where were you that evening?
I was dropping off a passenger at the Lights Out Bar and Grill.
Your Honor, may I approach the bench for the purpose of marking the exhibit?
Yes, you may.
I ask that this be marked as People's Exhibit.
People see?
People see marked participation.
Let the record reflect I am showing opposing counsel which has just been marked as People's Exhibit C for identification. Your Honor, may I approach the witness?
Yes, you may.
Let the record reflect I am showing the witness what has just been marked as People's Exhibit C for identification. Mr. Bickle, what is this?
This is a diagram of the area around the Lights Out Bar and Grill.
And is this a fair and accurate diagram of that area?
It is.
And besides scale, is everything accurate?
Yes,
And were you in this area the night of July 20th?
I was.
Your Honor, I'd ask that People's Exhibit C be moved into evidence.
Any objection?
Yeah, I just have one voir dire question for this document, Your Honor.
Yes, you may.
Mr. Bickle, did you prepare this document or create this document?
I did not.
Your Honor, I would object that since Mr. Bickle is not the creator of this document, there's a lack of foundation as this map is not to scale. Mr. Bickle may testify about his knowledge of the streets, but this would be inadmissible as he's not the creator of this document, has not testified to ever seeing this document previously.
All right, would the people like to be heard?
Yes, Your Honor. Investigator Kelly Severide rendered this diagram in her investigation. This map merely depicts where Mr. Bickle was located that evening, and since he was in that area, it is within his personal knowledge where he was, and I'm merely asking where he was that evening.
Okay. The court does not believe the proper foundation has been laid for this matter. I'm going to sustain the objection.
Mr. Bickle, the night of the fire, where were you?
I was outside the Lights Out Bar and Grill on Spring Street.
Your Honor, I believe the witness is referencing a document not in evidence.
Sustain.
May I ask that the document be removed from the witness as it's not in evidence?
Absolutely. That doesn't mean you can't try to reintroduce it later. But
Your Honor, may I have a moment to confer with my co-counsel?
sure.
So, Mr. Bickle, you're a taxi cab driver, right?
I am.
And where do you usually drive your cab?
I drive around this area all the time.
Your Honor, I'd ask that People's Exhibit C be moved into evidence at this point.
Any objection?
Yes, Your Honor. I would re-raise my objection as this witness has a lack of knowledge to authenticate this document as to its accuracy. He can testify about his knowledge of the streets and his personal experience, but cannot attest to the accuracy of this document as he didn't create it, take any photos, measurements, or take any steps to create this document, so therefore it would still be inadmissible.
People?
Your Honor, if allowed to continue, I will establish that Mr. Bickle has worked as a taxi cab driver for nearly 30 years, and he has much experience in this area, and as I previously asked him, this diagram is a fair and accurate depiction of that area.
May I be heard, Your Honor?
Sure.
I believe that this document may be entered into evidence if you deem necessary after that proper foundation has been laid, but not before.
Okay. I'm going to sustain the objection subject to foundation.
Mr. Bickle, do you normally drive in this area?
All of the time. I've been driving here for years.
And are you aware that Investigator Severide created a diagram to depict the area that you were driving in that evening?
I am aware, yes.
Objection, Your Honor. I believe that's an invention of fact and is inadmissible per Rule 701, as opposing counsel is not allowed to ask questions that are outside the witness's personal knowledge in their affidavit.
Would you like to be heard?
Yes, Your Honor. Since Ms. Severide interviewed Mr. Bickle, she asked him where he was that evening and used that evidence to subsequently create this diagram.
May I be heard, Your Honor?
All right, sustained.
Mr. Bickle, the night of the fire, when you were driving your cab, did you notice anything that evening?
I did. I noticed a person behind the lights out bar and grill.
And when you saw a person, was there anything obstructing your view?
There was not.
Were you wearing your glasses that evening, Mr. Bickle?
I wasn't, but I don't need them to drive at all.
And when you saw this person...
Objection, Your Honor. I would once again object invention of fact, as nowhere in this witness's affidavit does he state that he does not need his glasses to drive.
All right, overrule. I'll allow it. Give him some latitude.
Mr. Bickle, do you need your glasses to drive?
Not at all.
And when you noticed this person, what did you identify about them?
I noticed that they were wearing a baseball cap.
And did you notice anything else about this person?
Yes, I thought they looked identical to Lindsay Gordon.
How did you identify Lindsay Gordon that evening?
By her posture, her gait, the way she moved and walked.
And would you be able to identify Lindsay Gordon in court here today?
Absolutely.
Could you please do so based on an article of clothing?
Yes, she is the lady in the gray-blue suit.
Let the record reflect that the witness has correctly identified Lindsay Gordon, the defendant in this case.
So reflected.
Mr. Bickle, when you saw Lindsay Gordon in the alley that evening, were you able to identify her by her face?
No.
Why was this?
She had a baseball cap pulled over part of her head.
Now, Mr. Bickle, what, if any, actions did you take on August 1st, 2023?
I contacted arson investigator Kelly Severide.
And before contacting Investigator Severide, did you have any prior knowledge of the case facts?
Not at all.
And what specifically did you tell Investigator Severide?
I told her exactly what I saw that night. I saw Lindsay Gordon outside the bar the night of the fire.
Objection, Your Honor. I believe this is hearsay.
People, have you heard?
Your Honor, I'm asking Mr. Bickle what specifically he told Investigator Severide. Since this is a statement that he made, I'm simply asking him about that.
May be heard, Your Honor?
Yes, you may.
This is still an out-of-court statement that opposing counsel is bringing in for the truth of the matter, and therefore it's inadmissible for Rule 401.
I don't think she's bringing in for the truth of the matter. So I'm going to overrule the objection.
Mr. Bickle, what did you tell Investigator Severide when you spoke with him?
Like I just said, I told her that I had seen Lindsay Gordon outside the bar the night of the fire.
Nothing further, Your Honor.
Okay. Any cross?
Yes, Your Honor. Excuse me. May I proceed, Your Honor?
Yes, you may.
Good morning, Mr. Bickle.
Good morning.
You formed a business with the defendant in 2004, is that correct?
That's correct.
You invested every last penny into this business, yes?
Everything.
It's true that this business eventually failed, correct?
It did.
And when this business failed, you lost everything, yes?
Everything I had.
And you felt betrayed by Miss Gordon when this happened, is that correct?
I did. Her lies ruined the entire business.
And you were very angry at Miss Gordon for this, is that correct?
At that time, I was reasonably very upset.
And yes or no, you believe Miss Gordon's scumbag, is that correct?
I've said some things like that, yes.
And a crumb bum?
I've also said some things like that.
And you believe her an SOB as well, is that correct?
When I think about the things she has done in the past, I'm not very positive about it.
Yes to my question that you believe Miss Gordon an SOB?
I did call her that, yes.
In fact, didn't you assert that you would get back at Miss Gordon, correct?
Many years ago, I said that, but I was very angry, and I've moved past that since then.
Right, but many years ago, you said you would get back at Miss Gordon however long it takes, correct?
Like I said, in the heat of the moment, I was reasonably upset, and it's been many years.
Yes, but you didn't just assert this. You swore that however long it takes, you would get back at Lindsay Gordon. Is that correct?
I can't say that's enough. I was very angry in the moment, but it's been many years. I've mellowed out.
Right. And you've claimed you've put this anger behind you, correct? You've mellowed out, yes?
Yes.
Would you please tell the court what year your business with the defendant failed?
Around 2011?
That was 13 years ago, correct?
Yes.
And do you recall drafting an affidavit in this case?
I do.
And you created this affidavit in October of 2023, is that correct?
That's correct.
So even now, 13 years later, with your anger behind you, you call the defendant an SOB in your affidavit, is that correct?
I can still recall the fact that she has had some shady business in the past, and I'm not her biggest fan, while still moving past those feelings.
Just to direct you back to my question, Mr. Bickle, 13 years later, now, you called the defendant an SOB in your affidavit. Is that correct?
That's correct.
Thank you. Furthermore, you say you wouldn't lose any sleep if Lindsay Gordon is convicted. Is that correct?
I wouldn't lose any sleep if an arsonist was convicted of arson.
But I'm not speaking about anyone. I'm speaking about specifically Lindsay Gordon. You wouldn't lose any sleep if Lindsay Gordon is convicted. Is that correct?
If an arsonist was convicted of arson, I would not lose any sleep.
So, Lindsay Gordon, is that correct?
The arsonist, yes.
Thank you, Mr. Wheeler. And on the night of the fire, you were in the vicinity of Gordon's paint store. Is that correct?
Around the area, yes.
In fact, don't you testify to seeing the fire trucks at GPS while it was on fire?
I saw them heading down the street, yes.
And at 12:15 a.m. on July 29th, you saw someone, correct?
I did.
Yes. And you were driving your cab on the night of the fire, yes?
That's correct.
You were driving down South Poplar Avenue, correct?
Yes.
And that night was dark, yes?
That's fair to say.
And Mr. Bickle, yes or no, do you wear glasses?
I do, but I don't need them to drive at all.
Yeah, and you created an affidavit for this case, is that correct?
That's correct.
And in that affidavit, you swore to include all relevant testimony, is that correct?
I did.
And nowhere in your affidavit do you state that you do not need glasses to drive, is that correct?
That's correct. I was driving perfectly fine without them.
Objection, improper impeachment.
Like to be heard?
Yes, Your Honor. I believe I'm impeaching the witness by omission as they've admitted something out of their affidavit that they've testified to on direct examination that both contradicts something in their affidavit and is relevant testimony that they have not included.
People?
Your Honor, the counsel is trying to reference an out-of-court document as Mr. Bickle's affidavit is not into evidence or marked for identification. It is not admissible.
May I be heard, Your Honor?
Yes.
I'm not referencing this document for the truth of the matter, but rather to show inconsistency and impeach Mr. Bickle's credibility.
All right, overrule.
So I'll re-ask my question, Mr. Bickle. Nowhere in your affidavit do you state that you do not need glasses to drive. Is that correct?
No, but I was driving perfectly fine without them.
And you saw someone exiting an alley on South Poplar. Is that correct?
From Cat Alley onto South Poplar, yes.
And you weren't wearing your glasses on the night of the fire. Is that correct?
I was not.
And yes or no, while you were still on South Poplar Avenue, you were not able to immediately identify this person. Is that correct?
Not immediately, no.
And while you were still on South Poplar Avenue, you didn't identify this person as having the posture of Miss Gordon, did you?
Not specifically at that moment.
Right. And while you were still on South Poplar, you did not identify this person as looking like Miss Gordon either, did you?
No, I was largely focused on driving.
Yes. Right. And so after seeing this person, you then headed back towards the taxi depot, is that correct?
That's correct.
And in doing so, you drove halfway down Pine Street, yes?
Yes.
Yes. And after allegedly seeing this person and heading back to the taxi depot, that's when you realized this person might be Lindsay Gordon, is that correct?
Yes, I haven't seen her in years, and I was shocked.
Yes. So you drove back to confirm that this person might be Lindsay Gordon, correct?
Yes, I was shocked, and she had disappeared by the time I got there.
And this person you saw, they wore a cap pulled way down, is that correct?
A baseball cap, yes.
And this alleged person that you saw on a dark night, you didn't hear their voice, is that correct?
That's correct.
And when you drove back to confirm, you weren't able to, is that correct?
No, she had disappeared by then.
Yes, because the person had vanished, yes?
Yes, she had disappeared.
So you weren't able to confirm that it was Lindsay Gordon on that.
Objection asked and answered.
I'll allow one more time.
I'll re-ask the question, Mr. Mickle. You were not able to confirm that it was Lindsay Gordon on the night of the fire, is that correct?
That night, no.
And it's at this point that you thought of Gordon as an SOB, is that correct?
When thinking about the things she had done in the past, yes.
And to clarify for the court, on July 29th, 2023, shortly after midnight, you thought to yourself, I'd know that SOB anywhere, is that correct?
I would know her anywhere, yes.
Is that a yes to my question?
Yes.
2 days later, on August 1st, you contacted Investigator Severide, yes?
That's correct.
And did you speak to Investigator Severide via a phone call or an in-person interview?
I met her in person.
And you don't testify as speaking to the investigator on the 28th, is that correct?
Could you repeat the question, please?
Excuse me, you don't testify as speaking to the investigator on the 29th, is that correct?
That's correct.
Or the 30th?
That's correct.
Or the 31st, correct?
Objection relevance.
May I be heard, Your Honor?
Yes.
This goes to show that Mr. Bickle saw claims to have seen Miss Gordon, but waited 4 days before contacting the investigator, which greatly casts doubt upon whether or not he actually saw the defendant on the night of the fire.
People?
Your Honor, Mr. Bickle was not aware of where to take his findings to until that day.
All right, sustain.
Yes, Your Honor.
Next question.
You also spoke to Investigator Severide on August 3rd, is that correct?
That's correct.
And again, when you spoke to Investigator Severide on August 3rd, was that a face-to-face interview or a telephone call?
That was face-to-face, I believe.
So just to clarify for the court, on August 1st when speaking to Investigator Severide, you could only say you were pretty sure you saw Miss Gordon on the night of the fire, yes?
That's correct.
I have no further questions, Your Honor.
Okay,
Permission to redirect, Your Honor?
1 second. All right, people can proceed.
Mr. Bickle, is it fair to say that you are not the biggest fan of Lindsay Gordon?
That's fair to say, yes.
Would this affect your testimony in any way here in court today?
Absolutely not.
And how are you able to identify Lindsay Gordon the night of the fire?
I've known her for over 30 years now. I would recognize her anywhere.
Nothing further, Your Honor.
Okay, any recross?
I have no recross, Your Honor.
Okay, thank you, Mr. Bickle. You can step down.
Thank you.
Do the people have any more witnesses?
The people rest at this time, Your Honor.
Okay, are there any motions before the court?
Yes, Your Honor, at this time, the defense would like to call Miss Lindsay Gordon to the stand.
Okay, so no motions, no?
No motions, Your Honor.
Okay. And the defense ready to proceed with their first witness, correct?
Yes, Your Honor.
Okay.
We'd like to call Lindsay Gordon to the stand.
You said the box, you raise your right hand. Do you promise to tell the truth, whole truth, nothing but the truth?
I do.
Please have a seat.
Counsel, you can inquire.
Thank you, Your Honor. Good morning, Miss Gordon.
Good morning.
Please introduce yourself to the court.
My name is Lindsay Gordon, and I'm 59 years old.
What is your physical condition, Miss Gordon?
Well, if it wasn't for my asthma, I would say I'm doing okay. That is, for someone who's getting closer to being a senior citizen.
Where do you live?
I live at 1110 Hilltop Terrace in Bliss, Nirvana.
And what is your occupation?
Well, until recently, I was the proud owner of Gordon Paint and Supplies, or GPS, as I fondly call it.
Until recently? Please explain for the court.
There was a fire, and I lost everything.
When did you start GPS?
2016. I started my business from the ground up in April of 2016.
How did you finance the opening of GPS?
Well, I had a few dollars left over from a previous business, but I also took out a home equity loan.
And what steps did you take to open up your store?
Well, I hired a staff of employees, good folks, and I also took out insurance.
Why?
Your Honor, may I just reposition myself so I'm able to see Miss Gordon?
Yes, you may.
Thank you.
I can slide to the other side, Your Honor.
It's up to you.
That works too, thank you.
Okay.
My apologies. I can re-ask the question, Miss Gordon. Why did you take out insurance?
Yeah, well, I mean, you gotta have it, and I had a building full of combustible materials.
And how did your new business do?
Initially, the business was going swimmingly well, and so much so that in December of 2019, I had 25 employees on the payroll.
Did circumstances continue like that at GPS?
No, unfortunately not. Things changed.
When did things change?
Everything started to fall apart in March of 2020.
And why did things change, Miss Gordon?
One word, COVID. COVID had a big impact.
What impact did COVID have on your business?
COVID destroyed my supply chain.
How, if at all, did the break in the supply chain affect GPS?
Well, I mean, with COVID, I was unable to stock the shelves with paints and other supplies.
And what impact did that have on the business?
It had a significant impact, and business slowed to a trickle.
What, if anything, happened to your employees?
It broke my heart, but, well, I had to make some very hard decisions regarding my employees.
Please explain.
By May of 2020, I laid off 21 workers.
What, if anything, was the long-term impact of COVID on your business?
Well, in 2021, we had new orders starting to trickle in, and I would say this led to perhaps a calculated risk on my part.
What do you mean by calculated risk?
Well, I mean, I had dedicated employees, and I really did care about them. It troubled me to let them go. So I rehired 16 of my old employees and brought them back into the family.
So you say this was a calculated risk. Was there a downside to this calculated risk?
There was bankruptcy.
What do you mean by bankruptcy?
Well, I mean legally declaring that the business was broke. You see, GPS did not recover as quickly as we had hoped. Receivables were not coming in, and my total debt load became too high.
How did you learn that bankruptcy was an option?
Oh, well, that was from my financial advisor, Ryan Casey, and we would discuss bankruptcy frequently already in 2022. Even the new loan only helped a little. We still had difficulties.
What new loan?
Oh, well, while discussing bankruptcy over the summer of 2022, I took out a $250,000 loan, and one that I had to personally guarantee.
Did your bankruptcy discussions with Ryan Casey continue after the summer of 2022?
They did. The bankruptcy discussions continued as my financial difficulties continued into 2023. I shudder to think about it, but, well, it seemed as though something drastic might be required.
Drastic? Please explain for the court, Ms. Gordon.
Absolutely. Bankruptcy is drastic. Listen, if I shut the business down, if I filed for bankruptcy, then, well, there's my employees to think about, and they have bills to pay and mouths to feed too.
So, Ms. Gordon, we've discussed why you would not like to file for bankruptcy, but what would be the benefits to filing for bankruptcy?
It's tricky. Drastic, yes, but, well, you see, bankruptcy might also provide some hope, a little light, maybe even a fresh start for me and GPS.
I'd now like to move on to discuss July of 2023. Do you remember the night of July 28th, 2023?
Yes, of course I do.
And what were you doing that night?
That Friday night, I was at the Lights Out Bar and Grill.
Why were you there?
Well, my friend Ryan Casey and I, we'd agreed to meet there to listen to some music, catch up, maybe talk some business.
Were you and Ryan Casey together the entire time at the bar?
We weren't. Ryan stepped outside to take a phone call at around, I would say 12:10, and then I took the opportunity to visit the restroom, where I had to deal with some delicate matters. Anyways, we were apart for approximately 25 to 30 minutes.
Miss Gordon, delicate matters. Could you please explain a little further for the court?
I'm a bit embarrassed, but when I was in the bathroom, I had to deal with some, what I'll call gastrointestinal problems, if you know what I mean. Plus, it was a hot night, and I already mentioned my asthma, then factor in me forgetting my inhaler and the unair-conditioned bathroom. When I returned to my table, I was sweating and panting like a puppy.
When you returned to the table, did you interact with Ryan about this?
You know, I just explained to Ryan that I have asthma because he expressed some concern.
Miss Gordon, about how far is GPS from Lights Out Bar and Grill?
Oh, I would say it's around 5 city blocks.
And on the night of July 28th, 2023, did you walk to the bar?
Oh, no, not with my asthma on a hot night. Both Ryan and I drove to the bar, like usual.
So, Miss Gordon, today we've heard testimony from both Tracy Bickle and Pat Wheeler about their relationship with you, and I'd like to discuss that a little now. How do you know Tracy Bickle?
Well, a long time ago, Bickle and I were in a business together.
How did that business work out?
The business did go bankrupt.
And how would you say that affected your relationship with Miss Bickle?
I would say it affected it poorly. I mean, Tracy blamed me and said however long it took, he would get back at me.
Moving on, do you know a Pat Wheeler?
I do. Pat was a former employee of mine.
Why is he a former employee?
Well, I fired him shortly before the fire.
When exactly did you fire him?
It was back in late March of 2023.
And Miss Gordon, why did you fire Pat Wheeler?
Numerous reasons. I mean, he was refusing work, arriving to work late, and eavesdropping on my conversations.
What, if anything, happened after you fired Wheeler?
Right after I fired Wheeler, he made clear and direct statements to me publicly. He said, "You will regret this day. Mark my word."
Miss Gordon, do you have a security system at GPS?
Yes, we did.
And did you communicate to Mr. Wheeler about the security code?
I did tell him the code.
Miss Gordon, when you first heard about the fire, what was your first thought?
Well, I suspected that this was Wheeler's revenge, that he finally did it.
And Miss Gordon, did you ever, at any point, tell Inspector Severide in your interview about a possible suspect for this crime?
Absolutely. I mean, I told Inspector Severide about what Pat Wheeler had said.
Thank you, Your Honor. I have no further questions.
Okay. Any cross?
Yes, Your Honor. Good morning, Ms. Gordon.
Good morning.
On direct examination, you accused Pat Wheeler of committing arson. Isn't that right?
I believe that Wheeler was the one who set the fire.
So it's fair to say that you don't really like Mr. Wheeler, right?
I would say that Wheeler was not a great employee, no.
Great, you fired him.
Your Honor, may I just ask opposing counsel to just slightly move to the side so that counselors can see the witness?
Yes, Your Honor.
Okay.
Oh, yes, my question. You fired Wheeler, right?
I did fire Wheeler in late March, as I said on direct.
Because you believe that he was eavesdropping on a confidential call that you were having. Isn't that right?
I would say there is, as I said on direct, multiple reasons, and that was one of them.
Now, Ms. Gordon, surely if this call was confidential, you would have made sure that your door was closed, right?
I didn't believe that I needed to close my door. I was in my office, and I was the owner.
Surely if this call was so confidential, you would have made sure that your phone was off of speakerphone.
I often like to keep my phone on speakerphone just so I could multitask. I didn't see any worry in keeping it on speakerphone.
And surely if this call was confidential, you would have made sure that nobody else was in the room with you.
No, I wanted Leslie Neal to be in the room with me.
So, Ms. Gordon, to be clear, despite having another employee in the room, your phone on speakerphone, and the door open, you still claim this call is confidential.
I would say that it was confidential between me, Neil, and Casey.
And Pat Wheeler was outside the door.
Pat Wheeler was eavesdropping outside my door.
Ms. Gordon, I didn't ask if he was eavesdropping. I asked if he was outside the door.
Yes, he was outside the door,
That's why you fired him.
among other reasons.
Right. You also believe that Wheeler was stealing from GPS, right?
I briefly did have my suspicions about this.
Objection, Your Honor. I asked the relevance of whether Miss Gordon believes Pat Wheeler was stealing or not from GPS. It makes no facts important to this case, more or less probable.
People?
Your Honor, this is relevant because it goes to the credibility and bias of the defendant against Mr. Wheeler. Credibility is always relevant.
Overrule.
I'll just re-ask that last question. You believe that Mr. Wheeler was stealing from GPS, right?
I did have my suspicions about that.
But you never saw Mr. Wheeler stealing, did you?
I did not.
You never brought up these concerns to Mr. Wheeler.
I believe that I brought up the concerns to Wheeler.
So this is based on an assumption. You would agree with that?
I had my suspicions.
Now, I'd like to talk about your real estate business before working at GPS. You were business partners with Tracy Bickle, right?
In 2004, I was, yes.
Now, it's fair to say that you're not the biggest fan of Mr. Bickle.
No, I think that our relationship was ruined after Bickle blamed me.
Great. He blamed the entire business loss on just you.
Yes, absolutely, he did.
Miss Gordon, you would agree with me that Mr. Bickle put more money into this business than you, right?
I would say so.
So he would have lost more financially.
More financially, but I believe we both invested the same amount into the business.
Right, so Ms. Gordon, to be clear, you weren't completely honest with Mr. Bickle about the finances of the firm, were you?
Objection, Your Honor. This testimony is inadmissible per Rule 203 prior acts.
Like to be heard?
Your Honor, this is relevant because, again, it shows the credibility of Ms. Gordon, not only as a business partner in the past, but being on the stand today. Honesty and credibility is always relevant.
May I be heard, Your Honor?
Yes, you may.
Whether or not this testimony is relevant, it's inadmissible because it's going against the character of Ms. Gordon and her prior actions, and therefore is inadmissible per Rule 203.
All right, overrule. You can answer the question.
Could you repeat your question?
Now, Ms. Gordon, you weren't honest with Mr. Bickle about the finances of the firm, were you?
I wouldn't say that I wasn't honest about the finances.
Is it your testimony that you were honest with Mr. Bickle?
I would say that there was times when maybe I wouldn't tell Bickle everything, just saving him a headache, but
Ms. Gordon, yes or no, were you honest with Mr. Bickle about the finances of the firm?
I don't believe that I can answer that in a yes or no. I think there are some things that maybe I didn't tell Wheeler, but I never lied to I never lied to Bickle.
Well, you weren't forthcoming with Mr. Bickle about the finances, were you?
Right, there were some things that I didn't tell Bickle.
So no, you were not honest with him.
I wasn't always forthcoming, I would say.
And you were in this business for many years, right?
Yes, I would say that it was many years.
Right. So you knew that you had to fill out any type of financial document properly, completely, right?
Could you repeat that question?
Any financial document that you had to fill out, you knew that you had to fill it out completely and accurately.
Objection, Your Honor. Relevance. This testimony is more prejudicial than probative than, carries no probative value, as it doesn't make the fact more important to this case, more or less probable.
People?
Again, this goes to the credibility of the witness. I'm just emphasizing the fact that Ms. Gordon was not honest and forthcoming to Mr. Bickle about his finances, and I'm just exploring that credibility.
All right, overrule.
So I'll just re-ask. You were aware that you had to fill out any type of financial document properly and completely, right?
I would say so.
And you knew that, especially being a partner in this firm, you had to be ethical and forthcoming to Bickle about his finances.
Could you repeat that question?
You had to be ethical and forthcoming to Bickle about his finances, right?
I would say that we definitely communicated with each other.
But you failed to do that, right?
There were some things where I would say I was just trying to save him a headache.
You were not honest. You failed to do that. Isn't that right, Ms.
Objection, Your Honor. This has been asked.
All right, counsel, move on.
I'll move on now. Now, you talked to your financial advisor, Ryan Casey, in early 2022 about GPS and its finances, right?
I did reach out to Casey at this time.
And because of all the debt you were in, he advised you to take out a federally backed loan.
He did, and he helped me secure that loan.
Yes, and once you secured this loan, you would agree with me that it didn't turn around things for GPS in the long run, right?
Unfortunately, not as much as we had hoped it would.
And if things didn't turn around for GPS, you would just have to do whatever you had to do.
With regards to bankruptcy, yes, I did say that.
You didn't see bankruptcy as an option, though, did you?
I definitely was hoping against hope that my business would continue.
You would even hate to do anything drastic. Isn't that right?
Absolutely. I would say that bankruptcy is drastic.
Now, Ms. Gordon, to be clear, you had an insurance policy on Gordon Paint and Supplies, right?
Since I started my business in 2016, yes, I do.
A $2 million insurance policy.
Yes.
And after paying off all of your debts, you would pocket an additional $1.25 million.
That's the money that I would be left with from the insurance.
You could pay off all of your personal debt and professional debt.
I would say I would definitely pay off all my business debt.
All of your loans.
I would say the loan that I took out for my business, yes.
So, Ms. Gordon, you would agree with me that if you are acquitted from your charges today, you're going to emerge from this fire free and clear from debt.
I would say that I would be free from my business debt.
So you would be free and clear from your debt. It's a yes or no question.
Yes, as I said, yes.
Now, Ms. Gordon, let's talk about the night of July 28th. You arrived at the bar at about 11 o'clock to meet Mr. Casey?
I did, yes, the Lights Out Bar and Grill.
And he came shortly after, and he stepped out to take a phone call.
As I said on direct, he stepped out to take a phone call at around 12:10.
Now, Ms. Gordon, you were aware that Mr. Casey would have to take a phone call that night, right?
Ryan warned me that he might have to take a phone call.
Right, he was hesitant to go out because he knew he would have to do this.
Ryan did say this, yes.
But you insisted that he go out with you.
I did. I was looking forward to seeing him.
You told him that he could just leave the building and take his call.
I told him if he needed to, he could.
Meaning you were aware that Mr. Casey would be occupied with this call for some time.
I knew that he possibly could be on the phone call for around 20 minutes.
And Mr. Casey was taking his call for about 25 minutes.
Yeah, I believe he was.
And you claimed that you were in the bathroom for half an hour.
I was. As I also said on direct, I was dealing with some gastrointestinal issues.
Now, Ms. Gordon, to be clear, during this time period, you and Mr. Casey were not together, correct?
We were not.
And you're aware that Tracy Bickle saw someone exiting the back alley of Lights Out during the same time period.
I believe Bickle did say that.
And he said that they were wearing a baseball cap.
Yes, that's what Bickle claims.
Ms. Gordon, you were also wearing a baseball cap that night, weren't you?
I was wearing a Yankees baseball cap.
And in the same period of time, your business happens to burn down. Isn't that right?
My business did burn down when I was at Lights Out Bar and Grill.
And all of this happens in the same time period that you and Mr. Casey are not together.
Yes, I was in the bathroom at that time.
And when Mr. Casey came back to the table, you were nowhere to be found.
I was in the bathroom.
And when you came back, Mr. Casey had some questions for you. Isn't that right?
As I had already mentioned on direct, Casey asked me if I was okay, but I assured him I was.
Right. He asked you why you looked so anxious.
Ryan did ask me this.
Why you were completely out of breath.
Ryan did.
And in the next few minutes after this, Leslie Neal texted you, right?
Unfortunately, I did receive a text from Leslie about my building, my business.
You claim this is the first you ever heard about GPS being set on fire, right?
Absolutely. I was shocked. I couldn't believe it.
So you and Mr. Casey rushed over to the paint store in 2 separate cars, right?
We did drive over.
Now, Miss Gordon, to be clear, in the back of your truck, you had a gallon of gasoline, right?
I always keep some gas in the back of my truck, so I did.
And you heard Investigator Severide say today that gasoline was determined to be the accelerant for fire, right?
I believe that's what Severide claims.
Let's talk a little bit more about Investigator Severide. You talked to her the morning after the fire, right?
I did talk to Severide.
And you talked about your whereabouts the night of the fire, along with some general finances about GPS.
Yes, this is true.
Now, on direct examination, you never testified to asking Severide what happened to your business, right?
Well, I believe I know what happened to my business. It burned to the ground.
You never asked her what the cause was, did you?
I believe that Severide told me they believed it was gasoline.
But you never, I understand Severide told you, but you never asked Severide what happened, right?
I didn't ask. Severide told me.
Now, Miss Gordon, during this interview, a cigarette lighter fell out of your pocket, right?
I believe it did. It's from my grandpa.
And this lighter, it works, right?
I would say that it works about half the time. It's an old family heirloom.
It turns on, right?
It does.
So you can get a spark out of it half the time.
Around half the time, yeah.
So you also had this with you. You have this with you all the time, right?
Absolutely. It has great sentimental value for me.
So you had it with you on July 28th.
I always have it.
Which just so happens to be the day that your paint store was burned down.
Yes, unfortunately, that was the day that my warehouse burned down.
Nothing further, Your Honor.
Okay, thank you. Can you redirect?
Can I just have one moment, Your Honor?
Yes.
Permission to redirect, Your Honor.
You may.
May I proceed?
You may.
Miss Gordon, how long have you had a casualty insurance policy on GPS?
Well, I've had insurance ever since I started my business in 2016.
Nothing further, Your Honor. Thank you.
Can you recross?
No recross, Your Honor.
Okay. Thank you, Mr.
Thank you.
Step down. Does the defense have any more witnesses?
Yes, Your Honor. This time the defense calls Mr. Ryan Casey to the stand.
Okay. Mr. Casey, take the stand.
Please step to the box and raise your right hand. Do you promise to tell the truth, whole truth, nothing but the truth?
I do.
Please have a seat.
May I proceed?
You may proceed.
Good morning, Mr. Casey.
Good morning.
Would you please introduce yourself for the court?
My name is Ryan Casey, and I'm 56 years old.
Where do you currently live?
I currently reside at 12390 Nob Hill Drive in Bliss, Nirvana.
What is your educational background, Mr. Casey?
I graduated with my bachelor's degree in finance from Erie University.
Do you have any advanced degrees?
I do. After graduating with my degree in finance, I chose to pursue advanced studies at NYU.
Okay, and while at NYU, what was your focus of study there?
Business. I continued my focus in finance and graduated with my MBA, my master's in business administration.
Mr. Casey, what do you do for a living?
I am the proud owner and president of Ryan Casey & Associates, LLC.
What does Ryan Casey and Associates do?
We're a firm that offers financial planning and investment advice to businesses and individuals.
Could you specifically describe your financial planning work at Ryan Casey and Associates?
I'd love to. So we analyze our clients' assets, debts, cash flow, insurance needs, things of this nature. Sometimes we even help them consider bankruptcy.
Mr. Casey, do you know Miss Lindsay Gordon?
I do. Lindsay is a good friend and longtime client of mine.
All right, let's talk about the night of July 28th and the early morning of July 29th, 2023. Now, Mr. Casey, what were you doing on the night of July 28th, 2023?
Miss Gordon invited me to meet her at Lights Out Bar and Grill.
When did you and Miss Gordon agree to meet up?
She had called me 2 nights prior, and although I likely had to take a phone call that night, I could not help but go.
Why could you not help but go?
Well, I wanted to help my client Lindsay, and my favorite band was playing.
Your favorite band? What band was that, Mr. Casey?
Van Valen. I love their stuff.
Mr. Casey, what time did you arrive at the bar the night of the 28th?
I arrived at about 11:15.
And when, if ever, was that phone call you mentioned earlier?
I stepped outside to take my call at about 12:10, and it lasted till about 12:35.
All right, so after you stepped outside at around 12:10, when, if ever, did you see Miss Gordon again?
When I returned to the table, Miss Gordon sat down at about 12:40, looking a bit flustered.
Looking a bit flustered, could you please explain what you mean, Mr. Casey?
Lindsay returned from the restroom sweating and looking anxious, but this made sense.
All right, one last question on this. So when you stepped outside to take your call, about how long was the period of time when you didn't see Miss Gordon?
About 30 minutes in total.
Thank you. Let's now talk about your business. What is your business relationship with Miss Gordon?
Miss Gordon is a longtime client of Ryan Casey and Associates, so we would talk business on a regular basis. And following the COVID pandemic in 2022, we began having a series of intense conversations.
Okay, let's first talk about early 2022. Could you please briefly describe your business conversations with Miss Gordon in early 2022?
Of course. COVID caused difficulties, and we all know that many businesses struggle to stay afloat during this time. So we would talk about these difficulties.
Could you outline what that means, Mr. Casey?
Several things. Firstly, GPS had debts that I believed were too high.
You said several things, Mr. Casey. Were there any other examples?
Another example would be the account receivables. They were not coming in fast enough. So much so that the business was not stable. And then came July of 2022, which seemed a critical month.
Why do you call July 2022 critical, Mr. Casey?
In July of 2022, Ms. Gordon had to obtain a $250,000 government-backed loan, a loan she had to personally guarantee.
Was there anything else?
July was also a month that we talked about bankruptcy.
Mr. Casey, why did you discuss bankruptcy with Ms. Gordon?
You see, bankruptcy is a legal way to help those struggling with their debts.
How would bankruptcy have benefited Ms. Gordon?
Under certain circumstances, a debtor does not need to pay the full amount owed by their loans. And despite any potential downsides, this could give her a fresh start.
What would some of those potential downsides be for Ms. Gordon?
Well, for example, if Ms. Gordon filed for bankruptcy, then she might need to shut down the business and lay off all the employees.
Thank you, Mr. Casey. Let's now, one more question on this before we move on. How often would you discuss bankruptcy with Ms. Gordon?
Frequently. For the better part of a year, Miss Gordon and I wrestled with the tough possibility of bankruptcy.
Thank you. I'd like to direct your attention to your business relationships in early 2023. Did the subject of bankruptcy ever come up again in 2023?
Yes, it did. It came up in March.
Can you please explain what happened in March of 2023?
Well, I talked again with Miss Gordon about her financial situation.
What did you learn then?
I learned that GPS did not appear to be turning around.
Why do you say that?
Well, the balance sheet wasn't looking good, or the loan situation.
Could you please tell the court more about that loan situation?
The hope was that I could restructure the loans, especially since there was the possibility that the business could tank.
Mr. Casey, if the bank would not restructure the loans, were there any other possibilities before Ms. Gordon?
Well, there was the other reasonable option, bankruptcy.
What was Ms. Gordon's position on bankruptcy?
From my observations, Ms. Gordon did not want to declare bankruptcy and lay off all of the employees.
All right, but what was your advice to Ms. Gordon regarding bankruptcy?
Well, I told her what she needed to hear, regardless of whether she wanted to hear or not.
Mr. Casey, what did you think Ms. Gordon needed to hear in March of 2023?
Bankruptcy. That bankruptcy was always a reasonable option.
Thank you, Mr. Casey, for your time. Your Honor, I have no further questions.
Okay. Any cross-examination?
Yes, Your Honor. Permission to proceed.
You may proceed.
Good morning, Mr. Casey.
Good morning.
You own your own financial planning and investment firm, correct?
Yes, I own my beloved business, Ryan Casey & Associates.
And you have an extensive educational background in this field.
I do.
You believe yourself to be a high-caliber financial advisor,
Well, I am.
and that your clients are lucky to work with you.
They are indeed.
With all that being said, it's fair to say, when you give financial advice, you believe it to be sound.
My advice is usually good advice.
You give, in your opinion, the best course of actions for your clients to take.
I do.
Now, Mr. Casey, would you agree with me when I say that if one of your larger clients were to fail due to your financial advice, it would reflect poorly upon you as a financial advisor?
Could you please repeat the question?
If one of your larger clients were to take your financial advice and fail, it would reflect poorly upon you as a financial advisor.
Objection, Your Honor. I'd just like to bring the court's attention to Rule 702, which opposing counsel is asking my witness a question which is lies outside the fact pattern today. And per Rule 702, this allows the witness to answer in any way they deem necessary.
Okay, people?
Your Honor, I'm simply asking the witness his belief on the effect on his business, which is certainly within his scope, and he's free to respond however he chooses.
All right, overrule.
Yes, Your Honor.
Sorry, could you please repeat the question?
Mr. Casey, if one of your larger clients were to take your financial advice and fail because of that advice, would it reflect poorly upon you as a financial advisor?
Well, funny thing, that's not always the case. In the broad financial world, there's so many variables and moving parts that all the blame can't be possibly placed on me. There's so many other underlying causes usually.
All the blame can be placed on you, as you just said, correct?
Yeah, all of the blame could not.
Given advice, correct?
I would have given advice, that's what I'm paid for.
And your client would have failed.
Well, that wouldn't necessarily be my fault because of all the other factors in the business world. In fact, businesses usually fail because of other underlying factors, so it would not be my fault.
Mr. Casey, you testified on direct examination that your company takes into account those underlying factors when giving financial advice. Isn't that right?
Generally, businesses try to paint themselves better than they look, so there's usually other stuff hidden deep.
Is that a yes, Mr. Casey?
It is a yes.
Let's talk about the work you did with Lindsay Gordon. In January 2022, Ms. Gordon was struggling to restabilize her business after the pandemic, correct?
Her business GPS had not fully recovered from the pandemic.
So at that point, you recommended she take out a $250,000 federal business loan.
At that time, that looked like the best course of action.
Now, the only catch with this loan would be that Ms. Gordon would have to personally guarantee it, correct?
I wouldn't necessarily call it a catch. That was just one of the clauses of the loan.
Ms. Gordon was hesitant to personally guarantee this loan, correct?
It's a big risk, but through my vast knowledge of the gray areas of finance, I knew it was a risk worth taking.
Ms. Gordon knew that personally guaranteeing this loan would mean personal debt for her.
This could result in her personal debt, yes.
Now, this loan didn't work out the way you had hoped, correct?
It ended up not working out the way we hoped.
It had helped short term,
It did help short term, indeed.
but in the long run, the business was still losing money.
Well, due to other underlying factors, the business did end up losing more money.
Which is why, at this point, you recommended the defendant file for bankruptcy.
Bankruptcy was always an option.
Now, for people just without your professional background, filing for bankruptcy is often seen as a last resort, is it not?
Well, it does get rid of all the debt, and it can be seen as a last resort.
It would mean Ms. Gordon would have to let go of all of her employees.
Not necessarily. That could be one of the cases.
And in a typical case, she would have to at least temporarily close her business.
Typically, yes.
Which is why she was hesitant to file for bankruptcy.
Well, you see, bankruptcy, it's really, really humbling. No proud business owner.
Is that a yes, Mr. Casey?
Your Honor, I would just ask that opposing counsel allow my witness to finish their answer.
If
Let
I
me feel
may,
they
Your
can
Honor.
answer with a yes.
Hold on. Okay. You want to respond?
I don't believe the witness is answering my question. He's talking about what specifically bankruptcy is. I'm simply asking if Ms. Gordon did end up filing for bankruptcy.
I'm going to overrule the objection. I thought the witness was not answering the question.
Yes, Your Honor.
Could you please repeat the question?
Ms. Gordon was hesitant to file for bankruptcy because of this, correct?
Could you please explain what this is? I kind of forgot.
Ms. Gordon didn't want to fire her employees.
Ms. Gordon did not want to fire her
She
employees.
didn't want to temporarily close her business.
And no, she did not want to temporarily
So
continue.
she was adamant about not filing for bankruptcy.
It was her drastic measure.
Right. In one of these conversations, Lindsay Gordon expressed her frustrations to you over the phone, correct?
She did.
And in that conversation, she said she would hate to do anything drastic, correct?
She said this in relation to bankruptcy.
Mr. Casey, you don't specifically know what Lindsay Gordon was referring to, do you?
That's my assumption, yes.
It's simply an assumption.
Well, due to my financial caliber, and my long work and my long friendship with Lindsay Gordon, I'm almost positive it refers to bankruptcy.
But you weren't the one that made this statement.
No, I was not.
Let's talk about the night of July 28th. Ms. Gordon called you on the 26th to invite you out to drinks for the 28th, correct?
That is correct.
And in that initial phone call on the 26th, you informed the defendant that you would have to step outside and take a phone call with a relative, correct?
Well, not necessarily would. I wouldn't say it like that. It was a possibility that a phone call could come in.
And because of that possibility, you were hesitant to agree to go to the bar with her at first.
Yes, that's correct.
You told Ms. Gordon that this call would probably take around 20 minutes.
This call, if it came in, could take 20 minutes or more.
Yet Ms. Gordon insisted that you go to the bar with her that night.
She did.
Let's talk about that night specifically, the 28th. You and the defendant both arrived around 11 a.m., correct?
This is true.
And you were together from that point until 12:10 a.m.?
Yes, 12:10 was when I stepped outside to take my call.
You stepped outside the front door of Lights Out Bar and Grill, correct?
That is correct.
The main entrance of the bar,
One of the main entrances, yes.
which would be the sidewalk on Spring Street.
No, I believe it'd be the sidewalk on the South Poplar Avenue.
The front of the bar is facing Spring Street, correct, Mr. Casey?
Well, there are many main entrances, and that's what I believe you asked.
Now, when you were on your phone call, you were focused on your conversation, correct?
Yes, reasonably so.
You weren't actively looking for Lindsay Gordon,
I had no need to. I knew she was in the bar.
and you weren't actively looking down the back alley of Lights Out Bar and Grill.
I had no reason to look down the back alley.
Your call concluded around 12:35 a.m., correct?
This is true.
And at that point, you returned to your table,
I did return to my table, yes.
and when you arrived, the defendant is not there.
No, she was not. She was in the restroom.
You didn't see the defendant come from the direction of the restroom, did you?
Well, you see, that wouldn't really be good for our personal or professional relationship. So no.
You didn't see the direction where the defendant is coming from.
No, I did not.
The only knowledge you have of where the defendant was from 12:10 to 12:40 a.m. is what she told you.
That is correct.
Now, when Ms. Gordon returned to the table, she was sweating, correct?
This was because of her asthma.
Which is just what she told you, correct?
It's something I've experienced through my long working with the defendant.
Ms. Gordon wasn't actively having an asthma attack when she returned to the table.
Well, she was recovering from it, but it appeared as if she was having an asthma attack prior.
And when she returned to the table, she was also out of breath.
She was out of breath.
Now, let's talk about the insurance policy on Gordon Cleaning Supplies. As Ms. Gordon's financial advisor, you would be aware of this policy, correct?
I am aware of her insurance policy, yes.
Which is a $2 million casualty insurance policy.
Yes, one that she's had since April of 2016.
So, Mr. Casey, if Miss Gordon were to receive the insurance payout on this policy, it would be enough to extricate her from all her debts, correct?
Yes, if she received the payout from this $2 million policy, she would be cleared of her debt. It could pay for all her debt.
Enough to cover the debt on board and paint supplies, correct?
Yes, it could cover that debt.
As well as the debt remaining from that loan she had personally guaranteed.
Yes, it could cover that debt as well.
And if she, after clearing out this debt, Miss Gordon would net approximately $1.25 million, correct?
That is correct.
Which is $1.25 million more than the defendant would have if her business hadn't burnt down.
Yes, that would have been the case.
No further questions.
Any redirect?
Yes, Your Honor. Mr. Casey, you mentioned an insurance policy on Gordon Painting Supplies. Based on your knowledge, how long has Ms. Gordon had this policy?
Ms. Gordon has had her policy since April of 2016.
And you also talked about the financial problems at Gordon Painting Supplies. Could you just, to the best of your knowledge, tell the court about when was the time you first started discussing bankruptcy with Ms. Gordon?
Well, I can't really remember for certain, but I remember that prior to July of 2022, we had discussed bankruptcy multiple times.
Thank you, Mr. Casey, for your time. Your Honor, I have no further questions.
Okay. Any recross?
Yes, Your Honor.
Okay.
Mr. Casey, if Ms. Gordon were to receive her insurance policy, she would no longer need to file for bankruptcy. Isn't that correct?
Objection, Your Honor. Asked and answered.
Overruled.
I'll re-ask my question, Mr. Casey. If Ms. Gordon were to receive her insurance policy, she would no longer need to file for bankruptcy, correct?
There would be no need to file for bankruptcy.
No further questions.
Okay, thank you. Witness may step down. Thank you.
Thank you.
Okay, does the defense have any more witnesses?
Yes, Your Honor, at this time, the defense calls Ms. Leslie Neal to the stand.
Okay. Will Ms. Neal take the stand, please?
At the box and raise your right hand. Do you come to the truth of her testimony?
I do.
Please.
May I proceed?
Yes, you may.
Good morning, Ms. Neal.
Good morning.
Please state your name and age for the court.
My name is Leslie Neal, and I'm 31.
Ms. Neal, where do you live?
I currently live at 1905 Franklin Street in Bliss, Nirvana.
Please describe your educational background.
Well, I have a bachelor's degree in history and a master's degree in organizational psychology, both from Nirvana State.
Do you know Ms. Gordon?
Yes, she was my boss at GPS.
When did you start to work at Gordon Painting Supplies?
It was around 7, going on 8 years ago now. You see, I began in May of 2016.
Now, when you first began at GPS, what did you do?
I worked closely with the owner, Miss Lindsay Gordon, and learned a lot from her.
What specific tasks did you perform at GPS?
I mostly worked with promotional materials. I even got to come up with a tagline from one of our mailers, but I would really pitch in with anything.
You said you learned a lot from Miss Gordon. Can you explain for the court?
Gordon taught me how to manage. You could say run a business.
By what means did Miss Gordon do this?
Gordon was very hands-on. She worked side by side with me, helped us all accordingly, and interacted with us.
How did Miss Gordon interact with her employees?
She would talk to us and ask us for input, making the average employee like me feel appreciated in this and in other ways.
In what other ways did you feel appreciated?
For the most part, I loved my job and was very appreciative of it. Gordon treated me well and paid me well also.
What do you mean, for the most part?
There was this employee, Pat Wheeler.
Let's now talk about your observations of Pat. Now, you testified that you began working at GPS in 2016. Do you know when Pat began working at GPS?
He began later on in the same year, that is 2016.
To what extent, if at all, did you work with Pat?
Already in 2016, we were working side by side.
What observations, if any, did you make about Wheeler?
After the pandemic, I noticed he began coming in late. A lot. But that was just the beginning.
Please explain.
Coming in late was one thing, but I observed when Pat was given a job to do, he would refuse to do it. He was fired on March 24th, 2023.
Do you recall the events of March 24th?
Unfortunately, yes, I do. I will not forget that day for a while.
Was there any time you talked to the defendant that day?
Yes, Lindsay and I discussed financial matters. You see, GPS wasn't doing so well.
When you were discussing financial matters with Miss Gordon, can you summarize your conversation for the court?
Bankruptcy. Our discussions about bankruptcy really stood out to me.
How, if at all, does this relate to Pat Wheeler?
Like I said, Lindsay and I were talking. Although it was unbeknownst to us at first, we noted Pat Wheeler listening in on our conversation. This did not work out very well for him.
How so?
He was fired.
What happened after that?
He warned Lindsay Gordon about what might happen in the future.
What did he say specifically?
Pat said after getting fired, "You will regret this day. Mark my word."
Let's now talk about the night of the fire. Where were you on the night of the fire at about 10?
I was at a Noble gas station where I saw Pat Wheeler.
What was Pat Wheeler doing?
Well, he opened his trunk and took out a container.
A container? Please describe the container.
It was about a 2-gallon container. It held gasoline.
What, if anything, did Pat do with this container?
Well, he filled it up with gas.
What happened next?
We made eye contact, and Pat immediately looked startled.
What did Pat Wheeler do after that?
Quickly, he finished what he was doing, loaded this into his trunk, and drove off into the night.
On that night, when, if ever, did you see Pat fill up his car with gas?
Your Honor, I never saw Pat Wheeler put gas in his car tank.
Could you please confirm for the court which Friday this was?
This was the same night, July 28th, 2023, when just 2 hours later, the warehouse burned down.
Now, Miss Neal, what did you do after seeing Pat fill up his gas can?
I went home and fell asleep on my roof.
When did you learn about the fire?
I woke up to the smell of smoke. I saw the flames. I had to go down there and confirm that this was really true.
Did you drive to GPS?
Yes. Immediately I drove down there. I saw the fire trucks in the building ablaze.
After arriving, what did you do next?
I informed Lindsay Gordon via text that the building was burning down.
Now, Miss Neal, did you ever talk to anyone about the events of this night?
Yes, an investigator named Kelly Severide interviewed me.
What was this interview about?
I explained to Inspector Severide about seeing Pat Wheeler at the gas station on the night of the fire.
What was the sum and substance of this conversation?
2 things. Firstly, I explained to the inspector the day on which Pat Wheeler was fired. Specifically, I tried to make it very clear Pat's reaction to his firing and what he said to Miss Lindsay Gordon.
Can you please clarify what you told Inspector Severide Mr. Wheeler said?
You will regret this day. Mark my word.
Miss Neal, you said 2 things. What was the second thing?
Secondly, I described how I saw Wheeler at the gas station on the night of the fire. How after seeing me, he acted quickly, drove away without filling up his car, but taking this newly filled gas can with him.
Thank you, Your Honor. I have no further questions.
Okay, thank you. Any cross-examination?
Yes, Your Honor. Good morning, Ms. Neal.
Good morning.
You are an employee of Gordon Meat Supplies, right?
Yes, for almost 8 years.
Right, you worked there for almost 8 years.
Yes.
And your boss was the defendant.
Lindsay Gordon was my boss, yes. She was an amazing boss.
Right, you and the defendant had a good relationship.
Yes, we did.
You loved working for the defendant.
I really did. She was great to work for.
And you would do anything for the defendant.
Hyperbolically speaking, yes, I would.
You would do anything for her.
Hyperbolically, yes.
And during the pandemic, you were one of the you employees have done, isn't that right?
Yes, I was so thankful that I got to keep my job.
You, Pat Wheeler, and 2 accountants were kept on, right?
Yes.
But you and Wheeler didn't have the best relationship.
No, I wouldn't say that we did.
Right, you didn't like Pat Wheeler.
No, he was not the best person.
You accused him of refusing tasks.
He did refuse tasks on multiple occasions, yes.
You say he came into work late.
Yes, he did multiple times.
You even accused him of trying to steal your boyfriend.
Well, yes, he definitely was a factor in this relationship.
And after Wheeler was fired, you were thrilled, isn't that correct?
Yes, I believe we all were. He was not a good employee.
Despite that being a GPS lost one of very few employees.
Yes, I believe that it was a good choice for the business.
Now, Ms. Neal, on direct examination, you testified that you were at the Noble gas station the night of the fire, isn't that right?
Yes, I was, where I saw Pat Wheeler.
Right, you claim you've seen Pat Wheeler at the gas station.
Yes, I did see Pat Wheeler at the gas station on the night of the fire.
And you claim that Pat Wheeler must have been the one to commit this crime, isn't that right?
Well, Pat Wheeler told us to mark his words, so you can mark mine if you want. Pat Wheeler is an arsonist.
But you didn't try and talk to Wheeler that evening?
No, I did not. We made eye contact. He seemed really startled.
So really, you had no idea where Wheeler was going after you saw him?
No, I do believe he had some nefarious intentions.
But you had no idea where Wheeler was going?
No, but he did not fill up his car and just filled a gas can. It seemed really odd to me.
That's not what I asked. You had no idea where Wheeler was going after you saw him?
I did not follow him, so no, I do not know where he went.
And later that evening, you were the one to tell your boss that GPS was burning down.
Unfortunately, yes. I was the one to inform Lindsay Gordon via text that GPS was burning.
You texted the defendant, right?
Yes, I did. I believed it was the quickest way of communication.
So just to clarify, when you found out that your boss's business was burning down, you didn't find it necessary to call her?
I believed it was quicker to just text her so she could come right over. It was a shock.
But you didn't call her?
No, I texted her.
And Ms. Neal, on direct examination, you testified that Lindsay Gordon taught you how to run a business, isn't that right?
That is correct.
So naturally, you were involved in the financial management of GPS.
Lindsay was very open and honest about this.
You were aware of the efforts that Gordon took to try and stabilize her business?
Some of them, yes.
She laid off employees, as we already said.
Unfortunately, yes, due to COVID, we did have to lay off some employees.
She laid off 21 employees.
Yes, she did.
And to your knowledge, she had an insurance policy on her business?
Yes.
And you never discussed with her her failure to pay these premiums on her multi-million-dollar insurance policy, isn't that right?
I did not have access to any.
Firstly, this is outside the scope of direct examination, and further, Ms. Neal does not testify to this in her affidavit. Opposing counsel is asking her witness questions outside of the affidavit, and so per Rule 702, my witness can answer in any way she deems necessary.
All right, people?
Your Honor, in response to outside the direct, I am not confined to what is specified on direct, and in response to outside of her affidavit, I am merely asking her what or what not did she discuss with Gordon. I'm not asking her to speculate.
Okay, overall.
Could you re-ask the question?
To your knowledge, Gordon never stopped paying the premiums on her multi-million-dollar insurance policy, isn't that right?
I did not have access to the books, and this was not something Gordon had discussed with me.
Right, she never discussed that with you?
No, I didn't see it necessary. I never asked.
And you were also aware that Gordon took out loans to try and stabilize her business, right?
Yes, this was one of the many efforts she took to save the business.
And one of these loans was a $200,000 federally backed loan, isn't that right?
That sounds correct.
Which she would have to personally guarantee.
Sure.
So although she was responsible for her business before, now that GPS failed, she would be personally liable financially.
Objection, Your Honor. I believe opposing counsel is asking my witness to speculate.
If she knows.
Can you re-ask the question?
So although Gordon was responsible for her business before, now that GPS failed, she would be personally liable financially.
I'm not sure what Gordon, I did not have access to the books. I was not one of the business's accountants, so I'm not really sure what she would be.
And to your knowledge, Gordon had no way of paying back these loans, isn't isn't that right?
I was not Gordon's accountant, so I don't know what money she had or did not have.
You're not aware of any other income that she had coming in?
I was not aware of anything, no.
Nothing from Your Honor.
Okay. Any redirect?
May I have one moment, Your Honor?
Yes.
I have no redirect, Your Honor.
Okay. We're going to take a short recess, 5 minutes, and we prepare for closing. Ready when you're ready. Come to order.
So to recess, court to session.
Okay. All right, good morning again. We're getting set for closing arguments. Is the defense prepared to go forward with the closing arguments?
Yes, we are, Your Honor.
Okay, you may proceed.
May it please the court. This case screams reasonable doubt. Everything my co-counselor said in opening statements has come true during today's trial. Confirmation bias is the enemy of truth. 2 unaccounted for suspects. 1 seen carrying the accelerant just 2 hours prior to the fire, and an investigator who was not inclined to follow up. This case screams reasonable doubt. Your Honor, bad investigations lead to bad prosecutions and bad convictions. Today, the prosecution must be able to exclude every hypothesis except for the one of guilt. Your Honor, the entire burden of proof today rests on the prosecution's shoulders. They must prove my client, Lindsay Gordon, not probably guilty, not very likely guilty, but guilty beyond a reasonable doubt. And according to People v. James Mills on page 112, they must exclude to a moral certainty every other reasonable hypothesis. That is, the prosecution must be able to exclude every hypothesis except for the one of guilt, and that would appropriately include ruling out other suspects. Today, we make 3 points to that end. First, the prosecution's investigation into today's case was tainted, biased, and wholly inadequate. Investigator Severide made up her mind immediately, having tunnel vision from the very beginning and laser focused on one suspect and one suspect only. Investigator Severide was more concerned with her own career advancement than she was with finding the truth and getting it right. Your Honor, investigators are supposed to wait until all evidence is in before coming to their conclusion. Not with Severide. Severide came to her conclusion before filing her preliminary report, while knowing that Pat Wheeler had the motive, means, and opportunity to commit arson. Knowing that Pat Wheeler had threatened my client, Lindsay Gordon. Knowing that Pat Wheeler was seen in the area of the store on the night of the fire. Knowing that Pat Wheeler had fantasized about damaging GPS. And knowing that Pat Wheeler was seen carrying gasoline on the night of the fire. Severide ignores all of this and files her report anyway. Laser focused on one suspect and one suspect only. Investigator Severide was not looking for the truth. She was looking for Lindsay Gordon. And further, when the investigator finally interviewed Wheeler, after already filing her report, She completely breaks investigation protocol by warning and tipping off the suspect instead of waiting to see how he would truly answer. And then on the stand today, Investigator Severide said it's best practice to do this, to warn suspects and tip off witnesses. And worse, hard to believe, Your Honor, but it's true. This investigator finds someone with motive loading up on gasoline on the night of the arson, just blocks away from where the arson happened. And the investigator never asks where Pat Wheeler was that night. Pat Wheeler has no alibi at all. In fact, Severide never asked him for one. Never asked him where he was at the time of the fire. And then the report. Not only incomplete, but contains errors about matters critical to the case as to the alleged timing of the events occurring. According to Severide, things can vary by 5 minutes. Your Honor, the timing in this case is critical, and 5 minutes of error is enough for reasonable doubt. It's not only Pat Wheeler, Your Honor. Tracy Bickle, no matter how long it would take, swore to get back at Lindsay Gordon, no matter how long. Does Investigator Severide find out where Tracy Bickle was at the time the fire started? No. This investigator lacks credibility and competence. The investigation into today's case in itself creates reasonable doubt. Confirmation bias is the enemy of the truth. Second, the prosecution has simply provided insufficient evidence today, failing to rule out the possibility of Ms. Gordon's innocence, contrary to People v. James. Your Honor, millions of businesses suffered through COVID, and millions of businesses have insurance. That does not prove that arson occurred. The prosecution has not proven to you today that a crime was committed at all. They have not proven that this was not an accident. That is just what Severide presumed before even starting her investigation. Your Honor, we heard today how Ms. Gordon loves her employees, how she would never want to hurt them. Bankruptcy was her last resort because she cared for her employees and she's committed to them. The business burning down is the worst possible thing that could happen. Further, Ms. Gordon's understanding of the insurance was that it would only cover her business loans, not any personal loans she had. Further, Your Honor, the prosecution cannot place Ms. Gordon at the scene of the fire. Tracy Bickle, the identification witness in today's case, clearly is still very angry at Ms. Gordon for their failed business venture over a decade ago and is still holding a grudge. So the only ID we have is from a very biased witness who was in a moving car looking into a dark alley without their glasses on and alleges they saw someone with a hat covering the person's head, and they never saw the person's face. That is not a positive identification by any means. Bickle testified that he hasn't seen Gordon in years. He also testified that he was not able to identify the face of the person he saw. That is not a positive identification. Further, the testimony we heard today from Tracy Bickle was that he told Severide it only might have been Lindsay Gordon. So by his own words, he acknowledges it's not a positive identification. He even had to drive back to confirm but was unable. Your Honor, the investigator's entire case is built upon the testimony of a taxi cab driver who had to drive back to confirm any potential identification. In the state of Nirvana, we do not convict people based upon maybes and might have beens. Which then leads us to number 3, the prosecution's obligation to exclude to a moral certainty every other reasonable hypothesis. The prosecution must be able to exclude every hypothesis except for the one of guilt. And they have failed to do that today with respect to the other suspects. The prosecution claims that all evidence in today's case points to Lindsay Gordon, but let's continue with Tracy Bickle, Your Honor. The witness who, on the stand today, again, clearly still angry at Miss Gordon. The one who swore, however long it takes, I will get back at Lindsay Gordon. She saw the fire, she was there. She has the means, motive, and opportunity to commit arson and has not been ruled out by the prosecution today. And Severide took no steps to rule him out as a suspect. And then, Your Honor, we have Pat Wheeler, the Achilles heel, the death blow, the final nail in the coffin for the prosecution's case today. Pat Wheeler's own words and testimony scream reasonable doubt, and for sure cannot be ruled out with moral certainty as required by People versus James Mills on page 112. Pat Wheeler, the disgruntled former employee of Miss Gordon's, was fired in March for not doing his job. And on the day he was fired, he threatened Lindsay Gordon. He said, "You will regret this day. Mark my words." On the stand today, Mr. Wheeler admitted to having fantasies about damaging the paint store, Your Honor. That is a very specific fantasy, not just any general threat. He was seen buying a 2-gallon gasoline container on the night of the fire and was seen in the area of the store. Your Honor, the fact that the prosecution cannot tell you where Pat Wheeler was at the time of the fire requires this court to acquit Lindsay Gordon. Your Honor, from the beginning of time, people have fallen prey to confirmation bias, fixating their eyes on the first shiny object that appears in front of them, and it blinds them to all other evidence around. Confirmation bias is the enemy of the truth. This case screams reasonable doubt. 2 unaccounted for suspects. 1 seen carrying the accelerant on the night of the fire, and an investigator who was not inclined to follow up. This case screams reasonable doubt, which is why today we ask that you find for the defense. Thank you.
Thank you, counsel. Are the people prepared to proceed to their closing?
Yes, Your Honor. Permission to approach for the purpose of retrieving evidence.
You may approach.
May I proceed, Your Honor?
You may.
This is a case about lies, loans, and Lindsay Gordon. Someone who washed away her debt with a canister of gasoline and a spark. Today, the prosecution had the burden to prove, beyond a reasonable doubt, that the defendant committed arson in the 3rd degree and set her business, Gordon Paint Supplies, on fire. After hearing all the evidence and testimony presented today, it's clear we've met that burden. Let's go back to the beginning. Today you learned that following the pandemic, Gordon Paint Supplies was plunged deeper into debt. Unable to pay her employees, the defendant reduced her staff from 25 to 4. You heard from 2 of those employees today, Leslie Neal and Pat Wheeler. They testified to the stressful work environment at Gordon Paint Supplies, which was created by the financial stress the company was under. They testified to the additional work those 4 employees had to do just to stay afloat. The way the business was operating at this time was not sustainable, and the defendant knew that. As a result, she took out and personally guaranteed a $250,000 federal business loan. You heard testimony today that despite this loan, the defendant's business continued to fail. Only now, her personal finances were on the hook. It's at this point that Ms. Gordon was advised to file for bankruptcy by her close friend and financial advisor, Ryan Casey, who you heard from today. When Mr. Casey took the stand today, he told you that filing for bankruptcy is seen as an absolute last resort, a strong indication of just how dire the defendant's financial situation was. You learned today that despite this continuous advice from Mr. Casey over years, the defendant refused to file for bankruptcy. The defense has told you this was because she was desperate to save her business, but the evidence has shown just the opposite. Filing for bankruptcy would ruin Gordon's reputation, credit, and close her business. But if someone were to set fire to Gordon Paint Supplies and Lindsay Gordon could collect on her insurance policy, her reputation would be salvaged, her debt eliminated, and she would have the funds to reopen the business she loved so much. And that's just what she did. First, she manufactured an alibi, inviting Ryan Casey to Lights Out Bar and Grill the night of July 28th, knowing there would be a 30-minute period between 12:10 and 12:40 a.m. when Mr. Casey would have to step outside and take a phone call, providing the defendant with opportunity. You heard testimony today that Ms. Gordon was seen outside the Lights Out Bar and Grill, in the back alley of the bar at 12:15 a.m., contrary to her testimony. From this back alley, she could not be seen by Mr. Casey, who was taking his call outside one of the main doors of the bar, and she had the opportunity to sneak to her paint store. The prosecution submits it's within this 30-minute period that the defendant snuck out of the bar, ran to her paint store, staged a break-in, and committed arson in the 3rd degree. The next person to see the defendant was Ryan Casey when she returned to her table at 12:40 a.m. When Ms. Gordon returned, she was sweating and completely unable to breathe, almost as if she had been running, Your Honor. The defendant's only explanation for this is that the bar bathroom was hot. Your Honor, it's no coincidence that the time the defendant was completely unaccounted for and seen outside of the bar aligns with the time of the fire that would make her a millionaire. Kelly Severide from the City of Bliss Arson Investigation Department was tasked with conducting a complete and accurate investigation of this fire. Over the course of today's proceedings, the defense has attacked her tactics and credibility as an investigator. But you've heard of her extensive experience, working in the Arson Investigation Department for 15 years, as a police officer for 12 years before that. When Ms. Severide took the stand today, she testified to the routine procedure she followed throughout her investigation, including the diagram she created depicting the whereabouts of Pat Wheeler the night of the fire, who the defense claimed Ms. Severide didn't investigate enough. Your Honor, if Ms. Severide didn't investigate Pat Wheeler, why would she create a diagram with his whereabouts on it the night of the fire? You also learned of the physical evidence she gathered in relation to this case, including the gasoline residue and the lighter the defendant always keeps on her person. You learned today that the defendant had this lighter on her the night of the fire, giving her the means to commit this crime. The defense has claimed that this lighter works about half the time, that it's unable to start a fire. But a lighter doesn't need to work the first time to create a spark. Throughout her investigation, Ms. Severide conducted several interviews with past and present employees of Gordon Paint Supplies, including an interview with the defendant herself. During this specific interview, Ms. Severide learned that the defendant keeps a gasoline container in the bed of her truck at all times. Upon further investigation, Ms. Severide discovered gasoline droplets around the rim of this container, indicating it had been recently refilled, which was contrary to the defendant's testimony. Connecting the gasoline residue found at the scene to the gasoline the defendant had readily available the night of the fire as her truck was in the bar parking lot, Ms. Severide decided to look further into Lindsay Gordon. She discovered the defendant had motive after speaking to Ryan Casey, the financial advisor, and learning of the $2 million casualty insurance policy the defendant had on her business. Ms. Severide learned that this policy would be enough to extricate the defendant from all her personal debt, all her business debt, in addition to her pocketing $1.25 million. Ms. Severide also learned what we already know, that the defendant was completely unaccounted for from 12:10 to 12:40 a.m. With the time and resources Ms. Severide had to conduct this investigation, she explored all the leads. But all the evidence led back to Lindsay Gordon. The defense has fabricated a story, much like the defendant fabricated for alibi, that Pat Wheeler was the one to commit this crime. The basis for their accusation: after being fired the March before the fire, almost 6 months between the time of his firing and the fire, Mr. Wheeler appeared to be emotional and upset on his way out the door. Your Honor, this is a man who spent nearly 7 years of his life at Gordon Paint Supplies. He was there through COVID, through financial troubles, through the times when 4 people were doing the jobs of 25. And he feels that he was wrongfully terminated. Terminated for hearing an incriminating statement the defendant had made on the phone. It's justifiable Mr. Wheeler would be upset at the time of his termination. But just because he was upset at the time of his termination doesn't mean he's going to commit a felony. Lindsay Gordon had 2 million reasons to commit this crime. Pat Wheeler had none. And we should not let this story distract us from what the evidence has already proven today: that Lindsay Gordon is guilty. The defendant is being charged with arson in the 3rd degree, which states a person is guilty when they intentionally damage a building by starting a fire or causing an explosion. There are a few key elements to this law: the damage done to the building, the intention to start the fire, and the identity of the perpetrator. The defense has claimed that we haven't proven there was even a crime committed today. But the intention of the crime is clear through the presence of gasoline residue. This was no accident, Your Honor. Gasoline residue doesn't just appear on the floor of a paint store. The damage done to the building is completely undisputed. No one's questioning that the building was completely destroyed. And the identity of the perpetrator is what we're here to talk about today. And Your Honor, that's where the evidence is strongest. We've proven that Lindsay Gordon is facing bankruptcy. She had massive amounts of debt, both personally and on her business. She was seen outside the Lights Out Bar and Grill the night of July 28th, just minutes before her building would erupt in flame. And she had ready access to gasoline and a spark that night. In the case of People v. Sharon Van Hazen, the court ruled that permissible inferences regarding financial state may be made by a rational trier of fact in order to establish the defendant had motive. You've heard today that Lindsay Gordon had massive amounts of debt. Her only way out was receiving her insurance payout. The defendant was faced with a choice: arson or bankruptcy. The evidence has proven how she chose. Today, the prosecution had the burden to prove beyond a reasonable doubt that Lindsay Gordon committed arson in the 3rd degree and set her business, Gordon Paint Supplies, on fire. After hearing all the evidence presented today, it's clear we've met that burden. And it's at this time I ask you to hold Lindsay Gordon accountable for what she's done and return the verdict of guilty.
Thank you, Counsel. The court will take a short recess. Okay. Okay.
Good morning again, everyone. My name is Oliver Young, and I'm the chair of the High School Mock Trial Subcommittee of the Law, Youth, and Citizenship Committee. And I once again want to congratulate all 8 teams that competed in this Albany finals. The and especially the two teams that competed this morning. We witnessed an extraordinary exercise. So again, another round of applause. A funny thing happened to me last week. I'm in my day job, and I'm a personal injury lawyer in Buffalo, New York, and I work for a small PI law firm. And the founder of the law firm is looking to expand and move into open a satellite office in Niagara Falls. And it's a funny story, somewhat related to this mock trial case. Anyway, he's looking at a building up in Niagara Falls for the satellite office. And so he drives up, and I'm driving separately. He gives me the address. It's on Main Street in Niagara Falls. And he tells me, you won't miss it. It's easy to find. It's right next door to a paint store. And all the time I'm driving up to Niagara Falls to find this place, I'm praying that the name of this paint store is Gordon. It would have made my day. Turns out it was not named Gordon, but still. This was, again, a great match performed by two great teams and presided over by a great justice. So the name of your judge this morning is Judge Eddie McShan. And Judge McShan is an associate justice of the Appellate Division, Third Department, and that's here in Albany. However, he is a Supreme Court justice from Bronx Supreme Court. He's a graduate of St. Lawrence University and the Maxwell School at Syracuse and Syracuse Law School. He served as a law clerk to Bronx Supreme Court Justices Frank Torres from 1998 to 1999, and to Latia Martin from 1999 to 2008. His judicial career began in the New York City Civil Court from 2013 to 2018, and as an acting Supreme Court justice from 2016 to 2018. Judge McShan was elected in 2018 to the Supreme Court as a Supreme Court justice for the 12th Judicial District, where Bronx County is located. Now, the most important aspect or thing for us in Justice McShan's background is that he, and get this, he served as president of the Thurgood Marshall Jr. Mock Trial Program. So the judge very well understands what you've gone through over the past 4 months, and he knows well what mock trial is all about. So let's give a round of applause to Judge McShan. Turn it over to the judge.
First, let me congratulate both teams. This is probably unquestionably the best mock trial program that I have ever seen, and I have been doing mock trials for the past 25 years. So congratulations to both sides. Very well prepared, very well argued, very well organized. So congratulations to you both. And what a tough case. I mean, this case came down to circumstantial evidence. Both sides had very excellent witnesses. Congratulations to the witnesses. Witnesses don't get enough credit in mock trial program. But believe me, the witnesses, you do make a difference. I mean, the scoring is so close. So any loss of a point or any discrepancy that may have happened sometimes falls on the witnesses. So I want to give witnesses credit because you guys do not get the attention. It's like the lineman in the football game, right? The lineman never gets the credit. Only the running backs and the quarterbacks and the wide receivers, they get all the credit. But you guys are the linemen. You guys did a fantastic job, okay? The attorneys, phenomenal, both sides. Openings were great. Your closings were great. Direct cross, phenomenal. It's hard for a judge to decide, wow, how do we find a difference here? You're talking about a tough decision. And this is a statewide competition, so I'm sure you guys have plenty of practice. So by the time you get here, you have really performed to another level. So great job. You are the quarterbacks, you are the running backs and the wide receivers, so great job to you guys as well. All right, now you put all the pressure on me because now I got to decide whether Miss Gordon goes home or she's going to travel back to me and we're going to take up the Attica. We're not sure where we're going to go. Initially, let me state that I do believe the people presented a legally sufficient case. In other words, the case would have survived a motion to dismiss if a motion to dismiss would have been made after the people's case and after the end of the trial. So in terms of the circumstantial evidence, excellent job presenting your case, okay? Now I have to decide whether or not Mrs. Gordon walks up. Can the defendant please stand? All right. We have an officer around? No? Okay. In the case of the people of the state of New York, of Nirvana versus Lindsay Gordon, after reviewing all the evidence and hearing all the arguments, the court finds the defendant not guilty. The court does believe that the defense raised enough reasonable doubt to warrant such a finding. So therefore, Ms. Gordon, you are free to go home. Congratulations again to both sides. Which one?
Okay, that concludes. Defense is the team that won this year's competition.
Great competition. Yeah, great competition.
And up.